Court officer, madam. Madam court officer. Court officer, madam. Sir, court officer, madam, ಬಂದಿಲ್ವಾ? Madam court officer. Court officer, madam.
ಹೇಳಿ ಸರ್.
Madam, Saturday one mention ಮಾಡಿದ್ದೆ serial number 45. ತಾವು 27-9 ಕೊಟ್ಟಿದ್ರೆ ಅದು ಕಂಪ್ಯೂಟರ್ ಹೋಗ್ಬಿಟ್ಟು 27-10 ಆಗೋಗಿದೆ ಅದು.
ನಂಬರ್ 45
45 14337 ಅಂದ್ರೆ ಸ್ಯಾಟರ್ಡೇ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 14337 ತಾವು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೆ ಮೇಡಮ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಹಾಕೊಡ್ತೀನಿ ಅಂತ ಓಕೆ ಅಂದಿದ್ರು.
ಇಲ್ಲ ಸರ್ 45 27-10 ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಕೊಟ್ಟಿರೋದು.
ಅಲ್ಲ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಕೇಳ್ಕೊಂಡಿದ್ದೆ
ಇಲ್ಲ
ಸಾಹೇಬ್ರನ್ನ.
ಇಲ್ಲ ನೀವು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಯಾವಾಗಾದ್ರೂ ಅಂತ ಹೇಳಿದ್ರಿ, ಅದಕ್ಕೋಸ್ಕರ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ 27-10 ಅಂತ ಕೊಟ್ಟಿದೆ.
ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಕೇಳಿದ್ನಲ್ಲ ಮೇಡಮ್ ನಿಮ್ಮ ಹತ್ರ.
ಯಾಕಂದ್ರೆ ಈ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ಸ್ ಇಲ್ಲ, ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ವಾ, ಹಂಗಾಗಿ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಯಾವಾಗಾರು ಅಂತ ಕೇಳಿದಕ್ಕೆ ಹಂಗಾಗಿದೆ ಅಷ್ಟೇ.
ಮೇಡಮ್ 27-9 ಕೊಟ್ಬಿಡಿ ಪ್ಲೀಸ್, ಯಾಕೆಂದ್ರೆ ನನಗೆ ವಾಪಸ್
ಚೇಂಜ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಸರ್, ಸೈನ್ ಆಗೋಗಿದೆ ಮೊನ್ನೆದೆ.
ಮತ್ತೆ ಮೆಮೊ ಮೂವ್ ಮಾಡೋದಾ ತಮ್ಮ ಹತ್ರನೇ?
ಡೇಟ್ಸ್ ಇದೆ, ಇನ್ನೇನ್ ವೆಕೇಶನ್ ಬಂತು, ಇಟ್ಸ್ ಹೈಲಿ
ಅಲ್ಲ.
ಡಿಫಿಕಲ್ಟ್.
ನೀವೇನಾದ್ರು ಸೊಲ್ಯೂಷನ್ ಕೊಡ್ಬೇಕು ನನಗೆ. 27/9 ಅಂತ ತಗೊಂಡೋಗಿದ್ದು.
You tell me. अभी तो आई मैं कल से खा देना
ಹಲೋ ಹೇಳಿ. ಅದನ್ನ ನೋಡು ಚೇಂಜ್ ಮಾಡಿಸು 45 27/9 ತಪ್ಪಾಗಿದೆ ನಮ್ ಕಡೆ. ಅದನ್ನ ಹೇಳ್ಬಿಡು. ಅದು 27 ಇದು
ಇದೊಂದು ಬರ್ಕೊಡಿ ಮೇಡಮ್, ನಾನು ಚೇಂಜ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಏನು ಏನಾಗಿಲ್ಲ ಅಂದ್ರೆ ತಗೋ.
10 ಇರೋದನ್ನ 9 ಮಾಡಿಸ್ಬೇಕು.
10 ಸಂಡೇ ಇದೆ, ಚಾನ್ಸ್ ಇಲ್ಲ. ಅವ್ರು ಹೇಳೋದು ಕರೆಕ್ಟ್. ನಾವು 9 ಅಂತ ಬರ್ಕೊಳ್ಳೋದಕ್ಕೆ 10 ಬರ್ಕೊಂಡಿದೀವಿ ಅನ್ಸ್ತು. ಹೇಳ್ಬಿಡು ಅಷ್ಟೇ.
ಮೇಡಮ್ ಚೇಂಜ್ ಆಗುತ್ತಲ್ವಾ ಹಂಗಾರೆ?
ಹಲೋ,
ಚೇಂಜ್ ಆಗುತ್ತಲ್ವಾ?
ಹಾ ಚೇಂಜ್ ಆಗಿದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್ ಮೇಡಮ್.
ಹಾ List 1, page 1, see number 1 and 2. Page 2, see number 3 to 11.
My lords, serial number 10, my lords. Apologies, my lord. I'm mentioning a matter which is in admission list. My senior is suffering from a viral fever, my lords. Short accommodation.
Number 10 is you are for the appellant.
Appellant, my lords.
There are several other matters. Serial number 5. Oh, I'm sorry. Serial number 10.
10, my lords.
Section 34.
Yes, my lords.
This is listed for what?
This is listed for admissions, my lords. Kindly, my lords, a short week.
You inform the other side.
I'll inform, my lords.
Please inform immediately.
I'll
because
inform, my lords.
Stay has not been granted.
No, my lords. No.
8. You are for the appellant. Section 34, quantum. After occasion, of course. All matters which are being adjourned, please list it after occasion.
Page 3, number 12 to 20. Page 4, 21 to 23. Page 5, 24 to 27.
27, Lord.
Hmm.
I request Lord next Monday, Lord. Because
Monday?
start is Lord. Today is some medical this thing.
Next
Lord.
Monday not happening. We'll have it immediately after holidays. Yes,
Lord, a date may continue. Lord.
yes.
Page 6, 28 to 30. Page 7, 31 to 36. Page 20, number 60 to 62.
61, my lord.
Yes.
2 weeks, my lord. I'm for the appellant, my lord. Respondent
Also
also.
appear for respondent number 5.
Yes, BDA.
Yes, ma'am.
21, number 63. Page 22, 64 and 65. Page 24, 66 to 69. Page 25, 70. Page 28, 26, 71, 27. List 1, admission, seal number 1, Murugesh V. Charity.
But I request for 1 week time to file my translation and all. Okay,
4 acres in the very same survey number, denotified in 2000.
yes. No, but
Is that not the end of it? Denotified.
no, denotification happens. Not if it is award is not passed and possession is not taken. Not
Here also, the finding is that possession is not taken.
fine.
Whatever that be, in
I'll-
2000, the rest of the property in the very same survey number stands denotified.
Not what has happened is, not I should be able to establish before your lordships that I have substantially implemented Jnana Bharati layout, not in respect of a particular property. The concept of acquisition is incidental insofar as BDA Act is concerned.
We understand. The
Development-
question is this.
Yes,
When the preliminary notification is in 89, final notification in 97.
Yeah.
In 2000, the rest of the property in the very same survey number stands denotified.
yes,
And the finding is that possession is never taken.
yes.
Does it survive in respect of this property is the only
But I-
question. We understand that it need not be that it is in respect of the very same, whether you have implemented would be the question. But then, as regards this property,
Yes.
is there any action ever taken?
No, as regards this, yes, Lord, I'll produce all those judgments where the Honorable Supreme Court says, even if the scheme lapses, even if I am not able to substantially develop the schemes, the lands which are already vested in the state will remain with the state. The state can utilize that property.
That vesting to be complete,
No, that vesting to be complete, yes.
there must be possession also.
On the contrary, if I have substantially implemented, if section 36 is to be read and 27 and 36 are to be read in with each other, what happens is the provisions of the land acquisition will still remain. And there is no,
We agree on the proposition.
yes,
On the broad proposition, we are with you.
yes,
But in a case where the entire extent of the land in the very same survey number has been denotified, what remains and possession has not been taken.
Yes, ma'am.
What remains to be
Lord,
considered is the
ma'am,
question.
yes, ma'am. What-
Unless you can show that this now forms a part of the scheme
Yes,
area and that.
I will be able to show that to your lordship. I'll bring that, all those documents. And Lord,
Been
what has
specifically
happened?
considered by the learned single judge.
Lord, what, Lord, I respectfully submit that, Lord, these are the, Lord, the cases where, Lord, the learned single judges have considered a portion of the property, everywhere.
In
single
normal
portion.
cases, you are right. But in this case, the denotification makes a
Yes,
world
ma'am.
of difference.
No, Lord, even if it is denotified, the particular portion is retained, it is retained for a purpose. Lord, otherwise, Lord, the denotification, there was no impediment for the state government to denotify this portion of the property also. when-
All around lands also been
But
denotified.
I'll establish all that, Lord, with the records and with the sketch also.
Learned counsel for the appellant seeks time to produce further materials to substantiate the contention that the scheme has been substantially implemented in respect of the property in question as well. Just after vacation.
Please. And whether he has the locus to challenge it becomes an issue.
That we'll consider.
Yes, because he becomes a subsequent purchaser after the notification. And
But then it is in respect of the land in question.
yes,
We'll consider,
He-
because in an intra-court appeal,
yes,
you have to show that there is some patent error or illegality in the judgment failing which he cannot reappreciate the entire thing.
yes.
Yes,
Subsequent purchaser is itself is a,
subsequent purchaser is an issue which has been considered.
he
That-
will, that is what Supreme Court says, that they are not entitled to challenge acquisition, even seek for a lapsing of an acquisition. Not only challenging the notifications, but also the seek for a declaration that it has lapsed. I'll produce all those, please.
2, Radhakrishna Holla.
Of the appellant, my lord.
Yes.
Matter arises out of Industrial Disputes
Bottle
Act.
purchasers,
Yes, my lord.
admission of the charge.
Yes, my lord.
Now full back wages ordered.
Full
Back
purchase,
wages have now been ordered.
yes, the other single jury it has been ordered, my lord. My lord, let
On
me,
the last occasion, my lords have suggested for settlement, my lord.
but the parties are not willing, my lord, I can't help it.
Will have to be heard.
Yes,
We list it on
We are ready.
immediately after vacation. Immediately after vacation, we will.
Some date may be given. my
Yes,
lord.
yes,
The oldest matter, my lords.
yes.
3,
The dispute is of the year.
87. Dismissal of
87 dismissal, my lord, actually,
Yes,
award is up to 10.
please list it on a. Yes,
Later.
3, Mohammed Tahir.
Amarnath not there.
For the respondent number
Give
one.
the date so that they can say whether there is any.
Meeting ID बोलो.
Yes, item 3. Yes, fixing of boundaries, pending civil suit.
869.
एक second बोलो.
Notice issued at annexure at page number 57.
Hmm.
Stated copy is at page 2.
Hmm.
Wherein the Tahsildar had issued notice to survey the property of
Hmm.
the subject matter of the civil suit.
Hmm.
The power which the Tahsildar places in this under the Karnataka Land Revenue Act under section 61 here.
Hmm.
So he had issued a notice that
Land Revenue Act. Hmm.
that notice was challenged before the learned single judge, and the learned single judge quoting the pendency of the civil suit and allowed the repetition. Judges are kindly take section 61 here, because jurisdiction lies solely with the Tahsildar. 61. Relevant one would be 61H. Jurisdiction of revenue courts and bar of jurisdiction of civil courts.
Hmm.
Judges are kindly see clause H.
Please read the provision. Save as otherwise provided in this act.
Otherwise provided in this act or
Hmm.
any other law for the time being enforced.
Or any other law for the time being enforced. Hmm.
The revenue court shall have jurisdiction to recommend, decide or dispose of any matter which it is by under this act empowered to recommend, decide or dispose of, and no civil court shall have shall exercise jurisdiction as to any such matters.
Hmm.
The relevant portion for this case, your worship, is clause H.
The question is this.
Please.
Title is in dispute before the civil court.
Title is in dispute, Your Honor. Now, as regards the notice, it is only solely to determine the boundaries. Now, assuming I succeed or I fail in the civil suit, it is immaterial. This exercise is required only to fix the boundaries. Whether
Just a moment, just a moment. What does head say? Claims regarding boundaries?
Claims regarding boundaries fixed under this act or under any other law for the time being imposed, or to set aside any order passed by a competent officer under any such law with regard to boundary marks or survey marks.
Now tell us what is the suit?
For possession and permanent injunction.
On the strength of title. On the strength of title.
Yes, yes, sir.
The memo I have reduced the claim level. Before the civil suit, civil court is for a permanent injunction. Indicate the memo dated 31/8/2024 as produced the claim. Along with the translated form. For a permanent injunction order in favor of plaintiff and against the defendant by restraining them by law not to construct commercial complex illegally by the defendants and their gang, not to try such acts again. Any other reviews of this honorable court seems suitable. There is no prayer as regards possession, Your Lordship. It is a bare injunction suit.
Your lordship may kindly see section 62, your lordship. Your lordship, section 62 says, nothing in section 61 shall be held to prevent the civil courts from entertaining any of the following, namely, suit against the state government to contest the amount claimed or paid under so and so. Your lordship may kindly see clause B. Suits between private parties for the purpose of establishing any private rights, although it may be affected by any entry in any land record. Your lordship,
Absolutely. So
yes,
therefore,
sir.
nothing prevents the suit from proceeding.
Yes, your
Suit
lordship.
can proceed.
This
No
suit,
difficulty. Question is only whether the claim regarding fixing of boundaries of his property is barred by the suit.
yes, your lordship.
What is the finding of the learned single judge?
Section 62 specifically speaks about two private suit between two private parties, your lordship.
Correct.
They can
There's
claim.
nothing which stands in the way of the suit proceeding.
Yes, your lordship.
That is not the question. Now, what does the learned single judge say? What is the finding?
Paragraph number 4 may kindly be seen.
Nevertheless, it will not preclude the civil court from directing an inquiry or securing a report from the revenue authorities to identify the boundaries and therefore thereafter decide the case.
He's not.
Let
he's
them.
not going to give a finding or any.
Is this property that you have mentioned, the suit schedule property?
Yes,
Does that form part of the property that he is now claiming as a
yes,
boundary?
yes, your lord.
Forms part of the same.
Same
property.
Hmm.
For which the suit is pending.
Hmm.
Now, this is a statutory act, which is statutory provision under the act, which I filed a representation and the Tahsildar has issued a notice calling upon them in their presence to fix the boundaries.
What is your representation in respect of the property for which you have title?
Disputed title.
Disputed title.
Survey number 191, 192, 194 and 195.
It does not prohibit. Therefore, the question whether the question of title, if at all, if it is raised in a civil suit, that can be decided in the civil suit.
Let them make a necessary application before the civil court, your lordship, for the fixation of boundaries.
Why? Does it always have to be?
Your lordship.
What is your suit? That is a difficulty. What is your suit? Your suit is only a plain injunction suit.
Injunction suit.
Yes.
Your lordship, if your lordship may see section 61.
In evidence, it's a different aspect. Succeed or fail, it's a different aspect. Now, he is only exercising his jurisdiction, which is granted to him under the Karnataka land.
He does not even claim title. Yes, where is your contention with regard to title in the suit? What is your contention?
Memo. Starts from second paragraph, Your Lordship, page number 7. Translated copy.
No pleading on, there is no pleading on
There is
title.
no pleading,
There is no pleading on title.
Your Lordship, there is a division bench judgment of this honorable court, Your Lordship. Your Lordship may permit me to.
There is no declaration of title. There is no contention with regard to title.
Your Lordship may kindly allow me to refer this particular judgment of this honorable court, Your Lordship. Division bench judgment. Your Lordship may kindly see para number 10.
Para number?
10, Your Lordship.
Ah.
Seventh line, para number 10, seventh line.
Yes.
Whenever a jurisdiction, Your Lordship. It starts from whenever a jurisdiction, end of the line. Whenever a jurisdiction is conferred upon a court, all necessary powers in order to effectively exercise that jurisdiction are also deemed to have been contained in that jurisdiction, Your Lordship.
Where is the power conferred on the court to decide the boundary of a property in
Your Lordship-
accordance with the title in a injunction suit, plain suit for injunction?
Yes, Your Lordship. Your Lordship, if you read section, if Your Lordship may kindly say section 61, save as otherwise provided in this act or any other law for timing in force, a revenue court shall have jurisdiction to determine, decide, dispose of any matter which it is by under this act empowered to determine. Your Lordship, if Your Lordship may kindly see clause 2B, A. 2A, Your Lordship. Claim against government relating to any property apprehending to any office for any service whatsoever. This suit is particularly private suit, Your Lordship, between two private parties. Government is not the party. If the government is party, they can proceed with that.
So, counsel, that is not the issue. It does not preclude the decision on the issue by the civil court. Absolutely nothing prevents.
Please, Your Lord.
But what prevents the consideration by the revenue authorities under 61H is the question. Nothing prevents. This will not preclude you. If, as a matter of fact, you have a contention, injunction suit, you are aware, even on possession, you can seek it.
And moreover, Your Lordship, the suit which...
How will you be prejudiced by the fixation of the boundaries of his property? If you have a contention that part of that property, which he claims on the basis of his title, is in your possession, or that you have some title
Please,
to it, those are matters you can agitate in the civil court. Nothing prevents.
Moreover, the suit which the learned counsel is mentioning, the question which has been raised,
This
it
is
has
not the
been
same
withdrawn,
suit.
Your Lord. The suit has been withdrawn.
You withdrew the suit.
They have withdrawn the suit, Your Lord. They have filed the suit. They have withdrawn the suit.
More the reason why it should be decided here.
I'm just bringing to a kind
You
of...
will also be put on notice. You will be heard. It cannot be done otherwise. Your titles will also have to be examined.
Your Lordship, they have withdrawn this suit and they have filed another suit where they have not made us the parties, Your Lordship. Thus,
Again, therefore, there is no inter se suit between you at the moment. Now, the only issue is, while fixing the boundary,
please, sir.
his title deeds will have to be looked into. Your title deeds will have to be looked into. If there is any government land in between or anywhere in the vicinity, that will also have to be considered. That is all there is to it.
Please, sir.
So now we'll say that the suit has been withdrawn. But yes, after issuing notice, after considering whatever their objections are and the title deeds in question. Heard both sides. The heard the learned counsel appearing for the appellant, the learned government advocate appearing for respondents 1 and 2, as well as learned counsel appearing from third respondent. It is submitted by the learned counsel for the appellant that the finding in the judgment with regard to finding in the judgment under appeal that during pendency of the suit, the appellant could not have approached the revenue authority seeking fixation of boundaries is incorrect in view of the provisions of Section 61 of the Karnataka Land Revenue Act. The learned counsel for the third respondent has drawn our notice to Section 62 of the Act as well.
First respondent.
First, you are the first.
Respondent number.
Sorry. No, you are the third respondent. Just a moment, sorry, sir.
In the
Yes.
appeal, respondent number 1 year.
This is, we say, heard the learned counsel for the appellant, the learned counsel for the first respondent, as well as learned counsel, learned government advocate appearing for the other respondents. Learned counsel for the first respondent submits, has drawn our attention to Section 62 of the Act as well. Having considered the contentions advanced, we noticed that the suit in question was a simple injunction suit filed by the appellant as against the respondents here. It is submitted that the suit has subsequently been withdrawn as well. Full stop. Having considered the contentions advanced, we are of the opinion that the pendency of a suit in which an injunction simpliciter is sought cannot be a ground for non-consideration of an application made before the revenue authorities under Section 61. Full stop. The learned counsel appearing for the first respondent submits that the first respondent is also entitled to be put on notice and heard, and his title documents are to be examined while the application submitted by the appellant.
असलम दसे साहब अब नया स्टूड झाली ना वो क्या
Yes. What? The earlier sentence, please. Is being considered, first, having considered the contentions advanced and in view of the specific provisions of Section 61 and 62, we are of the opinion that though the question of title and possession is open to be considered by the civil courts, there would be no impediment to the consideration of an application for fixation of the boundaries on the strength of title by the Tahsildar concerned. In the above view of the matter, we direct that the application submitted by the petitioner is to be, by the appellant, is to be proceeded with in accordance with law. After notice to all concerned and after examining the title deeds of the of all the owners of the properties in question. Disposed of. Appeal is
Much ob-
accordingly disposed of. Four, Arvind Basappa Reddy. Change of khata belated,
Yes, ma'am.
delay in seeking.
Office objection. Yes, there is a 20 years delay, my lord.
Yes.
And the vendor, my vendor's vendor has accepted, my lord, the owner who is claiming
accepted it has been left up to the court, I mean, road.
The petitioners allowed writ of certiorari issues quashing the impugned order. As a consequence, the order made by the Tahsildar is revived. Revenue entries shall be restored in terms thereof within a period of 8 weeks. And further compliance report shall be filed before the registrar, failing which costs.
Yes.
15th day of November 2022. What has happened thereafter?
May I submit? Lord, entire survey, may I submit?
Money, please.
Lord, entire survey numbers 3 acres, 16 guntas, my lord. Out of which 4 guntas is kharab, my lord. So what remains is 3 acres,
3 acres,
16 guntas.
out of which
4 guntas are kharab.
4 guntas.
Guntas.
Okay. Yes, therefore, what is left is 3.12.
Yes, my lord. Out of that, my lord, it belonged to one Jagdish and Guru Prasad, the respondents number 1 and 2 here in my lord. My lord, they executed a sale deed on in 1992-93 in favor of the
My vendor.
appellant's vendor for an extent of 3 acres, 3 guntas. My lord, in that sale deed, my lord, 9 guntas, what is remaining, was shown as road. In that sale deed, road.
The first sale.
Please, my lord, it was only shown as sale deed, shown as road. My lord, thereafter in 2013, that is about 20 years later, this Jagdish and Guru Prasad approached the AC in an appeal, stating that their 9 guntas, the entire 3 acres, 12 guntas was, Hodi was executed, was made in the name of the person who had purchased it. They challenged that entry after 20 years before the AC. And the AC,
There is a 9 guntas.
9 guntas which has to come to me. So the Tahsildar was directed by the Assistant Commissioner to execute, to change the entry so far as 9 guntas are concerned. Tahsildar changed the entries in 2013-14, my lord. In MR 16 of 2013-14, 9 guntas were changed in the name of Jagdish and Guru Prasad. It was renumbered as survey number 77/5. Thereafter, that was challenged before the Deputy Commissioner by the appellant's vendor in a review petition manner. The Deputy Commissioner allowed and set aside that order, against which the respondents came up in a writ petition. They succeeded once again in the before the learned single judge. My lord, on the last date, I was directed to verify, as per the directions of the learned single judge, why the entries are not continuing in the name of respondents number 1 and 2. I am filing a memo. Lord, I found a number 1 and 2 so far as survey number 77/5 for the extent. These are the facts of the case. The vendor,
As a matter of fact, been complied with the learned single judge's directions.
please, my lord.
Already been complied.
Yes, my lord. It was always
You last,
And
can
we-
you turn to, yes. I repeat, my lord, 78, the page number, 10/9/92, the sale deed. In that, my lord, the operative portion, I mean, the schedule is shown at age 82, my lord. I'll read that, my lord.
Yes, 3 acres,
Details of
16 guntas.
Land, extended to 3 acres, 16 guntas. In survey number 77/1 is so and so, situated in so and so village, Atibelem, Anekal Taluk, Bangalore, urban district. Out of this portion of land acquired by road, except,
For road.
yes, ma'am, except this balance remaining the land extend to 3 acres, 3 guntas. That was the only things which was sold to me.
Therefore, the 3 acres, 3 guntas is all that is sold.
It is given to us. I have
Only 3 acres, 3 guntas.
3 guntas.
Therefore, 3 acres, 3 guntas, there is no change.
There's
the-
no
if
no issue.
Now in the Kata also, there is no change.
No change.
So how you agree by this?
9.
It's only the rest of the property.
Which is left up to the road is the portion which they are claiming. Well, I will no access to the places, movements. Not only me, there are other people who has to pass through. Otherwise, I would not have purchased the property itself. Because road was there, access. I thought it will be, I can make use of the place there. And the.
Just a moment.
Sorry, ma'am.
This says, this is subject, of course, to the real, the sale deed in vernacular. This says out of this is the translated version says out of this portion of land acquired for road.
Yes, ma'am.
If it is acquired for road, where is the question of changing the khata in favor of the
My lord,
respondent?
it was not changed as per the directions of the learned single judge, my lord. Initially, when the Tahsildar was directed to change it, my lord, by the assistant commissioner's order, then only the entries were changed. And the entry is run in the name of respondent number 1 and 2, even as on today.
Just a moment. Where is the order of the assistant commissioner which directs the change?
18,
Page?
1-8. Single judge order.
No, not
Sorry.
the judge's order. I mean the assistant director's order.
My lord, I have the copy, my lord. It is in vernacular language. May I pass on, me?
What does it say?
147.
Yes.
My lord, this was passed on 3/2/2014, my lord. Anekal Taluk Attibele Hobli, Adigondanahಳ್ಳಿ Grama Survey number 77/1 ರಲ್ಲಿ 3 acres 16 guntas Jaminu Pahani Tiddupadi ಬಗ್ಗೆ. So far as correction in the entries.
English version is
No,
147, English version also.
let's read this.
My learner was reading Kannada, that's how it's very well.
Yes. Please continue.
Please, ma'am. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆನೇಕಲ್ ತಾಲೂಕು ಅತ್ತಿಬೇಳೆ ಹೋಬಳಿ ಆದಿಗೊಂಡನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 77/1 ರಲ್ಲಿ 3 ಎಕರೆ 16 ಗುಂಟೆ 4 ಗುಂಟೆ ಖರಾಬು ಸೇರಿ ಜಮೀನಿನ ಪೈಕಿ 3 ಎಕರೆ 12 ಗುಂಟೆ 174/88-89 ರಂತೆ ಶ್ರೀ ಸುಬ್ಬಕ್ಕ ಓಂ ಮುನಿರಾಯಪ್ಪರವರ ಹೆಸರಿಗೆ ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದ ಆಸ್ತಿ ಆಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖದ ತಮ್ಮ ವರದಿಯಲ್ಲಿ ತಿಳಿಸಿರುತ್ತೀರಿ. ಆದರೆ 174/88-89 ರಲ್ಲಿ ಪುಟ ಸಂಖ್ಯೆ 1ರಲ್ಲಿ ಯಾವುದೇ ಆದೇಶ ಮಾಡದೆ ಪುಟ ಸಂಖ್ಯೆ 2ರಲ್ಲಿ ಸುಬ್ಬಕ್ಕ ಕೋಂ ಮುನಿಯಪ್ಪ ರವರು ಪವತಿ ಸಬೂಬು ವಾರಿಸ್ದಾರರು ಜಗದೀಶ್ ಮತ್ತು ಗುರುಪ್ರಸಾದ್ ಇವರಿಗೆ ಹೆಸರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 77/1 ರಲ್ಲಿ 3 ಎಕರೆ 12 ಗುಂಟೆ ಜಮೀನು ಖಾತೆ ಎಂದು ಆದೇಶಿಸಿದೆ. ಆದರೆ 1ನೇ ಪುಟದಲ್ಲಿ 174/88-89 ಎಂದು ನಮೂದಿಸಿ ಪುಟ ಸಂಖ್ಯೆ 2ರಲ್ಲಿ ಆದೇಶ ಮಾಡಿರುವುದು ತಿದ್ದಿ ರದ್ದುಪಡಿಸಿದಂತೆ ಕಾಣುತ್ತದೆ. ಅಲ್ಲದೆ ನಮೂದಿನಲ್ಲಿ ಸ್ಪಷ್ಟತೆ ಇಲ್ಲ. ಆದ್ದರಿಂದ 174/88-89 ರನ್ನು ಮತ್ತೊಮ್ಮೆ ಪರಿಶೀಲಿಸಿ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಕ್ರಯ ಪತ್ರದ ವಹಿವಾಟಿನಂತೆ ಖಾತೆ ವರ್ಗಾವಣೆ ನಿಯಮಾನುಸಾರ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 128 ಮತ್ತು 129 ರಂತೆ ಕ್ರಮ ವಹಿಸಲು ಸೂಚಿಸಿದೆ. So it states that it was passed, that entry was made without any order or without any passing any order or verification, and hence it should be verified and it should be corrected. Accordingly, my lord, it was changed as I have produced in the memo, my lord. My lord may kindly look into the
Changed in the name of the?
changed in the name of Guru Prasad, the respondents number 1 and 2.
1
my
and
lord,
2.
to the extent of 9 guntas. And it was given a new survey number 77/5. So 77/1 remains 3 acres 3 guntas and 9 guntas was given in the name of Jagdish and Guru Prasad.
Now, what is your contention with regard? 3.3, there is no difficulty.
There is no dispute.
Your property
Yes, safe.
is in your, and it's in your name also.
Yes, ma'am.
Khata is also in your.
Correct.
The 9 guntas that it has been retransferred to the respondents is your problem.
The road.
Because it, according to you, it
Yes,
was a road.
confined to road.
It was a road which could be used by everybody.
Yes.
Is your contention. Where is that dealt with by the London Single Judge?
Sorry, Mala?
Where is the contention dealt with? You were heard.
My position, what is given, the road.
Heard
Yes, ma'am.
by the
I'm
London Single
not heard. Tahsildar did not hear me at all.
Where you
Sorry.
heard, but
Ma'am, sir.
before this court, you were
The-
heard.
Yes,
You were
yes.
put on notice and heard.
Yes, yes.
Yes, what was your contention before the London Single Judge?
ಹದಿಮೂರ. I quoted 18.
This is the
Yes, ma'am,
finding.
13.
The finding of the learned single judge is the 1992 sale deed refers to only 3.3. And the rest is not there, therefore it remains in the possession and in the name of the respondents.
Correct.
That it has been formed as a road.
Correct.
My lord, that entry is only in the sale deed, my lord.
Oh, it was,
That is the entry made by the respondent number 1 and 2 while executing the sale deed. Whether it is a road or not, that issue is never there.
there is no question of any acquisition for a road.
No, my lord. It is written by them in that entry is in the sale deed only. That is the instructions given to me. There is no road as such. So 9 guntas had to go to respondent number 1 and 2.
For a civil suit.
Yes, my lord.
Mela, sorry, Mela. I simply put it, Mela, 82, you lots, I already pointed out. You lots to see the bottom.
That, yes.
Bottom of 82, the respondent names are there. They have signed a signature,
Correct, that is true.
making a road.
Which is why we are saying it's a
Yes.
matter for a civil suit. If as a matter of fact, there is a road there
Correct,
and you are entitled to use of the road going by your deed.
correct.
Then, and the further transfer in your name.
Yes, ma'am.
It's a matter for a civil suit. Whether it is a road or not, how do we decide? Because the official respondents say that there is no other acquisition for the purpose of a road.
Correct.
Therefore, now the question would be that 9 guntas, which is now in the name of the respondents, whether you can use it as a road.
Correct. Not only me, yes, ma'am. Me, road means, my lord, it is not accessible, as I said.
Either it is an
I-
explanatory right or it is left as a road for your use by the document.
Correct.
Civil suit.
For that, my lord, actually, the Tahsildar should have conducted a thorough inquiry. Instead of that, what he says is in his order, there is some corrections are there. That correction has to be, at least, he has to put me also there and find out what are the issues and what are the roads are there and all that. Instead, this order is passed. Only my statement, my lord,
Not a
at
matter-
this stage,
Well, we can issue notice to the respondents and if they come, probably if there is any chance of settlement, that can be explored. Otherwise, it's a matter for a civil suit.
let them come.
Only a matter
I
of-
will, yes, satisfy this one.
Yes. Heard the learned counsel for the appellant as well as the learned advocate appearing.
My lord, I'll take notice for respondent number 1 and 2. Respondent
Takes
number
notice
3 and 4.
For respondents 3 and 4. You notice to the private respondents.
With ಕೊಟ್ಟಿದ್ದೀನಿ ಇಲ್ಲ ನಿಮ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ
The
ಇದೆ 9 ಗಂಟೆ 16
appellants
ಅವರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ
may also explore the chance of settlement of the disputes if any.
Very well, blame.
Yes, the memos are placed on record.
Please, ma'am.
The memo filed by the learned government advocate is taken on record. Yes,
After vacation, ma'am.
after notice. 5, Prakash Angadi. 5, 11,
5, 11, 14 and 29 minutes, called by judgment of issue.
yes,
And R2,
50%.
DC may be permitted to take notice.
I'll take notice for the,
yes. Five, 11,
5, 11, 14, 29.
15, 20.
9.
R3 is going to take that dispensation. In 29, there is a 2 days delay in filing the appeal. That can be controlled.
please, Manoj, I have no,
29,
I have no.
heard both sides. In view of the averments in the affidavit filed in support of the application, the delay of 2 days in filing the appeal shall stand controlled. Same marks in all the 4. Only in 29, there is a delay. 6. Manisha Kangu.
The appellant.
Section 34 dismissed, non-deposit
Here
of
for the-
75% of the amount.
My lords, I beg to appear on behalf of the appellant in the matter, my lords.
Yes.
My lords, my apologies for not being there in person today, my lords. I was scheduled to come from Chennai. My lords, I've just been given to understand by the appellant that they are unfortunately not in a position to make the payment, my lords. The company is run into severe losses and there's been no business in the company, my lords. I would like to proceed with the matter on merits, my lords. If I can just kindly seek for maybe 2 days, my lords. I'll be there in person to argue the matter in merits, my lords.
May make a submission, my lord. They have filed this appeal, taking new grounds which were not urged in this one, all that.
All that we'll consider on the merits. Now, since they are not able to make the payment, there is no interim order. We'll
No
list
interim
it
order, that's, your lordship may observe it so that we can go
view
ahead
of
with
the
the
fact that-
execution.
My lords, in fact, the execution proceeding is scheduled to be listed
Yes, my
tomorrow,
lord.
my lords. I'm
Let
only
us leave it
seeking
here.
an adjournment of maybe 2 days, my lords. I'll be there in person to argue, my lords, because I'll need some time to
No,
prepare.
my
I was
lord, this is
instructed
not
just
fair, my
yesterday.
lord. This is not fair.
Yes.
My lords,
Neither I am
I'm
allowed to execute it, nor they are paying any amount.
my lords,
And-
I'm only
We'll
seeking.
take the matter
I'm-
immediately after holidays. Immediately after holidays, we'll give you a list.
But
We
your
cannot-
lordship
we
may
cannot
make a
take-
mention that interim order is, please, my lord.
My
So
lords, I'm
that
only seeking
I
your
will cut-
indulgence.
My lord,
Proceed on the
their
next day.
intention is only to dodge the things. They
My
have
lords-
been dodging so many unnecessary things they take up. Not,
My lords, I'm-
neither pleaded in the, before the arbitrator,
Understand,
not in the 34.
we are in season, we are hearing the matter. We'll list it immediately after holidays. Don't precipitate it on the next date, that is all. Immediately after holidays, the matter can be taken up and heard.
It may be taken up for final hearing. not
Very
in
well, my lords.
admission.
I'll be there in person
Admission
to
will not,
argue.
because they go on taking the timing.
My lords, in fact, the
And your
EPs.
lordship may make a mention that they are not deposited, no interim order.
List this matter for final hearing on after holidays, please. Give a date.
2110.
My lords, in the meantime, if the EP is listed
Chaudhary?
tomorrow, my lords, let them not precipitate, my lords. Otherwise, I'll come on Thursday and argue, my lords.
14th or 15th of
Yes, it cannot be heard on Thursday. This court will not have the time to hear you.
I
on
understand. I'm at your lordship's hands, my lords. My only difficulty is the EP is listed tomorrow,
Lordship
my
may fix
lords.
a date on 14th or 15th, my lord, immediately after.
2110.
Yes.
7. Girish Kumar B.
Please,
Very
ma'am.
grateful.
Section 8 dismissed.
Section 8 dismissed. My lord has heard this at matter at length earlier also. There is a stay on the suit.
We'll have it on immediately after the holidays.
Very well, very well. Synopsis also has been submitted.
We'll
Very
give a list. Date.
2110.
2110.
grateful.
8 adjourned. 9. Anirudh.
Yes. 35 lakhs with 18% interest.
Yes, my lord. My lord, in this matter, what happens is the appellant, my lord, engages an advocate before the commercial court. The order sheet, my lord, it says that they have filed their wakalat on 4th November. So subsequently, we are also not aware what happens. However, the advocate stops appearing in the commercial court. So they, in 2 more hearings, my lord, the order sheet is there in page number 17, if my lordships may have. Page 17 is the order sheet, my lord. My lordships can see she, VG, files wakalat for defendant and praise time. So and subsequently, my lord, the advocate stops appearing. So therefore, the court takes away the right to file written statement, then posts for arguments and files a final order also on 15th February, my lord. Judgment is passed on 15th February. So, my lord, my only humble submission is that even 120 days had not expired since the day of filing the wakalat. Because as per commercial code, we have 120 days to file the written statement. And my lord, again, the reason for the advocate also not appearing is not the part of the advocate, partly because the patient himself, I mean, the appellant himself was hospitalized. From page number 40 onwards, I have put his medical certificates and his X-ray and all the other reports, my lord. He had a severe spondylitis. So he was also hospitalized and he's an old person, my lord. So he's aged also around so on medical reasons, he was just hospitalized. '63. Notice to be issued, my lord. And my lord, meanwhile, I'm asking, as is the IA1, my lord, IA number 1, for staying the judgment and decree of the lower court, my lord, because they might have filed an execution proceeding and probably warrant will be issued against him.
Yeah.
Yes, my lord, because we have not received any notice as of now. So in the meanwhile, if it,
Will receive notice when it is filed.
yes, my lord.
Yes, issue notice.
But if it can
emergent
be
notice to
stayed-
Respondents.
Obliges.
10 adjourn, 11, Prakash.
They
and
move for execution, please move it. We'll consider.
Oblige.
12, Siddharth B. Muchundi.
Hearing on behalf of the respondent,
Section 34 allowed.
section 34 that was allowed, what was
This
set
is
aside? What was set aside?
just a minute. IDI Limited. Is
ITI
this
limit.
the case of the cinema theatre, running of the cinema theatre.
Please.
Award is set aside.
What is set aside?
LOI is found to be not a binding contract.
Yes, my lord, the LOI has to be read in terms of the tender. So there was a finding by the learned arbitrator. But he.
Where is the appellant? Yes. Yes. Section 34 allowed and the award is set aside.
Award set
On the
aside.
finding that the LOI is not a binding contract.
Please, Milord. Because the issue, Milord, it's involved is, may kindly see there was a tender which was allotted. After that, Milord, the LOI came to be signed. And,
When was the tender?
Milord, the dates,
Tender dated 10/2/2017, man.
10/2/17.
Right.
When is the LOI?
18/5/2017.
under the LOI, Milord, there are certain responsibilities that are given to me. And based on that, Milord, I went ahead, Milord, took all the permissions, sanctions, everything was done. And Milord, EMD was also, Milord, received. In the LOI, Milord, there was an undertaking that they would have detailed, Milord, lease agreement will be entered into between the parties. At that point of time, Milord, the undertaking as per the LOI, Milord, it would be, Milord, 4 years, 11 months into, Milord, 4 terms. Totally, Milord, 20 years, Milord, was the understanding. Thereafter, Milord, there were certain conditions like what was the, Milord, the power which was supposed to be given by, Milord, the landlord. It was about
65 kV.
please, 160 kV originally agreed upon. Thereafter, Milord, the issue, Milord, came that, Milord, they said that instead of 20 years, we can maximum give, Milord, 5 years. Thereafter, Milord, regarding the power also, because, Milord, theatre, which was an AC with, Milord, about 400 seats. So, Milord, 160 kV, we could not have, Milord, reduced on that. So, Milord, furtherly, we agreed, Milord, to operate without the air conditioning, Milord, with 45 kV also. That also compromise for my end. With regard to, Milord, the
So
period,
some kind of an in-house cinema theatre.
it was theatre. It was old theatre, which was supposed to be renovated by us. It was, Milord, a very famous ITI theatre, which has, Milord, stopped operating from several years. Now, Milord, they called upon us, and there was only one, Milord, person, Milord, bid. Milord, was a successful bidder. No one else, Milord, applied also. Thereafter, Milord, we, Milord, went ahead and took all sanctions, permissions, everything. We invested a lot of money. Milord, have placed on record all the, Milord, thing. Thereafter, Milord, they started saying, Milord, we are not agreeable to this. Milord, their drafts were exchanged between the, Milord, parties. They, Milord, then came up, Milord, they are not able, on certain conditions, Milord, they were not agreeable. That's the reason, Milord, I had to, Milord, approach. And the nature of, Milord, specific performance was sought. And
What was the award?
award, Milord, may kindly see the
Claim was allowed in part.
Milord.
Counterclaim dismissed.
Dismissed.
Claimant is entitled to relief of specific performance. Directed to execute a
Execute
lease
the
agreement
release.
in terms of the LOI dated 18/5/17.
And some of 40 lakhs, Milord.
40 lakhs.
Well reasoned order, Milord, considering all the aspects, Milord, and section 34, Milord, there was the scope wasn't there, Milord, to interpret, but there's a decision, Milord, taken by the discretion used by the arbitrator. I'm not holding, it's not a question, Milord, of binding LOI at that point of time. There's a tender. In terms of the tender, Milord, the LOI is prepared. And Milord, it's consciously signed by the no, they not come back and say that, Milord, there was a competency, other things, Milord, they were not signed. And not only being signed, in terms of the LOI,
What is the specific finding on which it is overturned?
my lords will have the page number 54, Milord, 54 of the appeal memorandum. Page para number 26. In para 16 and page number 19, the learned arbitrator held that it was of relevance of notice that subclause 3 of 25 provides for execution of lease license agreement, and subclause 3B stipulates that the license agreement shall prevail over the tender document. On the contrary, page number 21, para 17, the learned arbitrator held that it was already emphasized. The LOI prevailed upon the tender document in the matter of giving effect to the rights and obligations of the parties under the contract. In page 23, in panel number 19, the learned arbitrator held that at the risk of repetition, it may be emphasized that the binding LOI has overriding effect and the relevant time of voluntary execution of such material document. The claimant company was admittedly incorporated.
That was another objection raised.
Please, Milord. Please.
Who were not incorporated as of the date when you bid.
Please, but having
By
said
the
that,
time the LOI was executed, you had been incorporated? No.
no, it was not
Thereafter.
incorporated thereafter. But that was objection never raised for about 4 years. They went ahead, made us to spend a lot of money, take our approvals, all that incorporated. Point number 29, it is clear that there was no concluded contract inter-se between inter parties. So letter of intent cannot be construed as a binding contract. No, this is the wrong finding, which is paragraph number 29 of the learned.
We only wanted to know on what material that was entered into. Reasons must be stated.
May I place the LOI and the tender documents before this court,
We can hear it on
Please,
an agreed date immediately after. So also takes notice to the.
trial court records may be called for Manager.
And seeks time to place. Both the counsel seek time to place arguments in the matter. Call for the trial court records. They're
Please, Madam, because
relevant.
You have already filed
tender-
paper books, it would be not convenient, we could refer to that,
28th October.
please.
Please. Great.
That's all.
13, Nidhi B. The appellant, my lord.
My lord, for the respondent number 1, I undertake to file wakalat in this matter, please, madam.
Yes, learned, so-and-so learned counsel undertakes to file wakalat on respect of R1.
R1, please.
My lord, R2 to R4 are the arbitrators. Notice may be
Yes, notice to
Yes.
R2 to R4 is dispensed.
obliged.
List after vacation, give a listing, please. After 28.
28-10.
28. That's
Obliged. 14 urgent, 15 Manmohan PN.
Here again, JDA,
Yes, Lord.
32%.
Yes.
There is a supplemental agreement which is
True.
referred. Is that discussed in the judgment?
Trial court, Lord, does not go into it in depth. Says, Lord, there are two clauses, Lord. One clause
Five.
says 5A, Lord, provides 32%.
Correct.
But if I put up construction, Lord, in the penthouse, etc., Lord, beyond third floor, Lord, he gets 3, Lord, penthouses, which in fact I gave it to him. He released them, Lord, through, Lord, supplementary deeds.
That is, does the supplementary agreement and
Yes, ma'am.
what its effect have, is it discussed by the,
Lord, there is no, Lord, detailed discussion about it. Court says, Lord, supplementary documents are executed, but ultimately says these are not penthouses, these are apartments, therefore they're entitled to 32%. That is the finding, Lord.
the supplemental agreement was to the effect that
Releasing, Lord,
if you make further,
no, Lord.
No.
Supplementary agreements, Lord, to the effect that releasing, Lord, these 3 apartments that were, Lord, or penthouses which were given, Lord, to the plaintiffs, that they said, because we are unable to pay the amount, we are releasing it in your favor.
why should they pay the amount?
But what happens is they have to give deposits, Lord, BWSSB deposit, electricity deposits, Lord, etc. They had to release and they needed some funds.
For the 32%,
No, not for 32%.
for the three.
For those 3,
penthouses.
Lord, the 3 penthouses. Yes, they,
Penthouse
Lord,
or apartment?
yes, Lord. They
Whatever.
gave that and Lord, entire thing is over. No, Lord, in fact, Lord, of course, has to come on record also, but I place it on record. Subsequent, all these apartments are sold. Now, Lord, they're asking for us to execute, Lord, this 32% in their favor. In fact, there's an arbitration clause, but I have to concede there's no specific contention raised. I'll have to point out to the court, but there is an arbitration clause between the parties. Therefore, Lord, suit itself was not mentioned.
Not raise it.
Lord, I have not raised it, no doubt about it.
Notice to the respondents. Issue notice to the respondents, emergent notice to the respondents. List immediately after.
But can I seek for stay, Lord, because
Stay of
the Lord impugned the judgment and decree. But because in fact it has been sold, Lord, I'll have certain other consequences.
list immediate. The direction is to.
Lord, direction, Lord, this decree is to the effect that, Lord, they're entitled for 32%. And Lord, I'm supposed to, Lord, execute all these documents. I have to give them 32%. The order decree says not to deliver 32% of the super built up area. Because rest of the properties I've given it to them.
Yes. Yes, will be a stay of further proceedings.
Great.
Stay of further proceedings on the basis of the decree. till the next date of hearing.
Great.
16, Amit Mandigi.
That is the matter which your lordships had heard on the last occasion regarding the arbitration maintenance.
Maintainability decided by the arbitrator, is it an award?
That is all
Owned against-
decided, my lord, as per law. When we go before a court, maintainability has to be decided first, not at a later. So it was decided by the learned judge saying it is maintainable. Interim order granted. Where is the question of, my lord, again going into this, and he ignores the first order passed by the court.
Yes.
Totally illegal.
When do we hear this?
My lord, if possible today itself, my lord, it's a very short point. In fact, there are just two questions that arise for consideration. Point number one, is the impugned order of the arbitrator an arbitral award? My lords, if it is not an award, nothing else needs to be considered. If it is an award, are there grounds made out under section 34 to interfere with that decision? My lord, these are the two questions that arise. If it is not an award, my lord, which is my respectful submission, because it does not dispose of any of the parties' rights and obligations. The arbitrator makes an award. We file an application under section 33, which we are entitled to do within 30 days, saying that there is one mathematical correction that you have to make, and there are certain claims of ours which have not been decided. And without that, those claims being decided, my lords, the job of the arbitrator is not complete. In fact, my lord, this is the second round of the arbitration.
Yes.
There is a partnership firm which has assets. Those assets will have to be disposed of. My lord, the partnership firm has been ordered to be dissolved.
Is there any chance of a settlement?
No.
Yes, we can list it on another day. We don't think it can be heard today.
Last week of October, my lord, because till then I'm not in the country, I'll be returning and interim order.
List it on,
Here.
on the last day.
For a date be fixed, my lord?
28th.
Very well.
28th.
October.
Because I'll be returning only on 25th.
28th.
28th.
28th of October.
That's fine. I oblige, my lord. I'm interim
Yes.
order to be continued.
Till then.
Highly oblige.
17, Krishna Swami, yes, Pradeep.
Section
Switching
34.
side.
Just a moment, is 19 also connected?
Yes.
19 is connected.
But what happened, but I will explain.
One is section 34, one is section 9.
Section.
Hmm?
Section
19.
19 is concerned, my lord.
Yes.
I had the benefit of section 17 order throughout. The arbitral award is in my favor. And my lords, I had a section 9 order also in my favor until the court disposed of the section 24.
Section.
Therefore, my lords, I'm asking that I be protected, my lords, due to the pending
Item
19.
Yes.
But as far as the
Section 9 dismissed post award.
post-
Award set aside, therefore nothing survives is the final. Yes. 4 crore 20 lakh 51,731 with interest at 8.54%. Yes, I was a little surprised by the 8.54. As a matter.
Rounded off figure, my lords.
Yes.
It was a technical tribunal comprising of engineers. There was one lawyer on the tribunal, so my lords, I'm sure that they must have been.
Correct.
But as far as the main matter is concerned, what happened is this. I supplied equipment to the restaurant. They did not pay on time. In fact, they kept delaying the supplies also, and supplies were heavy. And therefore, they had to incur warehousing costs, etc., because their site was not ready. They established power, and I supply equipment to power. So, both in consideration of the delay and the additional costs that I suffered because of having to arrange for warehousing. But we entered into a MOU, because like a one-time settlement. So if ever comes an arbitration stage, give them one more opportunity to pay. They said that we will pay a sum of rupees, there are two components in this MOU. The MOU is entered into on 8/2/2018. The original agreement is in 2015, 2015. So in the MOU, what they said is, for the principal amount, we will pay you 3.66 crores. It also includes both the warehousing costs, etc. And around instead of 2.48 crores of the accumulated interest, we will pay you 1.5 crores in 3 tranches. So what they do, they default on that. So I commenced an arbitration and I said that this is in the nature of a conditional agreement because it was all predicated upon complying with this. Since they did not comply, they were in breach. I rescinded that contract. Therefore, that contract is of lower rate. The arbitral tribunal relies upon judgments of the Calcutta High Court in Mediation. Say that I am entitled to receive within the conditional agreement, and therefore, my lords, their obligations under the previous agreement of 2015 are revived. This is the decision of the arbitral tribunal, and a very detailed reasoning has been provided, paragraphs 112 to 119. My lords, I will be there. What the trial court does, my lords, in the section 34 is all the other grounds under section 34 are rejected. On this ground, my lord, although novation is not even pleaded, neither in the statement of defense in the arbitration nor in the section 34 arbitration, he says this constitutes a novation of the contract. The MOU that has been entered into is not really anything else but a novation of the contract. Therefore, the parties' liabilities under the 2015 agreement stand extinguished, and therefore, what can only be enforced is the obligation created by the 2018 contract. Whereas, and then what he does, and he says that I don't agree with the interpretation of the Calcutta judgment that the arbitral tribunal has relied upon. I am relying upon the judgment, but their interpretation should have been different. Whereas, the short point is this: if there are two plausible views, whereas in section 34 proceedings, one plausible view cannot be replaced by another. That is the short point of the time. The file court record may have to be summoned, otherwise I can find a paper.
And what is the protection you sought in the section 9?
What was in my favor? The they are obviously in a financially hazardous condition, and therefore there was the order of sake that they should not dispose of any of their assets. Either they can provide an undertaking, or can be pleased to order status quo as far as their assets.
We'll hear it, we'll call for the records and hear it immediately after vacation till such time. The
No, they had the
protections
benefit
can
of,
continue.
their benefit, my lord, they also had it earlier. I have not alienated until. At that point, they had the benefit,
Yes.
that interim order. Now they wanted to attach my entire property, their plant and machinery. That was filed, section 9 was filed under that, that was rejected.
Yes, heard both sides. Both the call for the lower court records and list. In the first week of November?
Or it will be the same day as the previous matter, 28.
28.
And we will
Yes.
file papers.
Yes, paperwork shall be filed in the meanwhile. It is submitted by the learned counsel appearing for the respondent that the properties of the respondent will not be alienated till then. Said. 18?
May I?
Yes. Here also section 9.
Section 9, my lord, an interim
JDA.
pay- an interim pay was made.
Refundable security deposits.
Yes. And in fact, my lord,
46% and 54%. Contention is that GPA is only with regard to 54%.
what, my lord, is the finding, my lord, in fact, the learned judge, my lord, could not have gone into it because, my lord, the learned judge says these are all the domain of the arbitral tribunal. Very importantly, my lord, after the building was constructed, insofar as the constructed area and the super built up area, my lord, the sharing was done. But documentary evidence was put before the court below to show that this is a commercial building. In fact, after the landlords, my lord, got their area of share, assigned it for the purpose of renting, my lord, finding out a tenant was, my lord, my owners. And for which even, my lord, the brokerage charges, etc. were fixed. And, my lord, depending upon, my lord, their authorization, we found a common tenant. The owners, my lord, in respect of their share, join us executing, my lord, lease deeds in favor of, my lord, a single tenant, my lord, a huge tenant, it's a building, huge building, my lord. In fact, we couldn't have found, my lord, sundry tenants because, my lord, this has to be occupied as an entire building. And they started troubling, my lord, even the tenant on a frivolous ground that there is a particular sum of our area that there is no registered lease deed in respect of that. Then, my lord, what the tenant does, tenant also would go to court seeking an order of injunction. Tenant, my lord, would get an order of injunction. My lord, I have produced it. That order, my lord, tenant also subsequently came
Because
before this honorable
court says that there is nothing to show that your tenants were, the tenants were, as a matter of fact, harassed.
In fact, my lord, kindly see, my lord, the writ petition order I have produced,
Just a
where the
moment, just a
tenant, my
moment.
lord, came before this honorable court.
Just a moment with the business and so and so. Further, he argued that due to misconduct of these respondents, SmartWorks for Working Spaces, which is now the tenant,
Yes.
has filed a civil suit as OS number so and so, seeking injunction. I've carefully gone through the police complaint and plaint. No doubt a police complaint has been lodged. But nowhere in the complaint, this applicant has made clear as to the dates on which these respondents interfere with the business transactions of the applicant. Further, if we peruse the plaintiff in the above suit, plaintiff never made allegation against these respondents that they are interfering with their business transaction, instead of which they sought for relief of permanent injunction against this applicant from creating third-party rights pertaining to North Tower. This is the finding.
My lord, may kindly have, my lord, page number, my lord, 554 for a moment, my lord, next year QQ, volume 2. The tenants, my lord, came before this honorable court. Tenants, my lord, in fact, it was, my lord, the storyline was the same. If my lord, may kindly have, my lord, volume 2, page 554, next year QQ. The entire story was appreciated by this honorable court. And
554.
554, my lord. The relevant portions, my lord, should kindly find on 557. I'll just read, my lord, only so much. On page number 557, the petitioner is plaintiff in so-and-so on the so-and-so court. On the ground that it's a tenant in the suit scheduled property and there is a dispute as to who is entitled to collect the rents. Petitioner here has filed OS number so-and-so with the following reliefs. My lord, I just skipped that. Then, my lord, page number 558, paragraph 2. Along with the original suit, the plaintiff has also filed an application under 151 CPC following for the following prayer. Then, my lord, page number 559. The petitioner and plaintiff have also filed an application under 39 rule 1 and 2 with the following prayer. Then, my lord, paragraph number 4, the trial court, based upon the pleadings and the material placed before it, came to conclusion it's not a fit case to grant an ex parte interim order, and hence passed the following order. Aggrieved by the refusal of the ex parte interim order, the present writ petition is filed on the following prayer, etc., etc. Then, my lord, paragraph number 3, my lord, on page number 560, the operative portion. Issue emergent notice. In the meanwhile, the respondents are directed to not to interfere in the peaceful possession and the enjoyment of the petitioner over the suit scheduled property. In addition thereto, the petitioner is permitted to deposit the rents payable by it before the trial court. My lord, this is the relief granted to, my lord, the common tenant. But now, a CMP is filed, my lord, and the matter has to be, my lord, thrashed out by the arbitral tribunal. My lord, two submissions, my lord. Number one, there was a clear case of dispute. Either I am correct, they are correct, my lord, that had to be, my lord, attended to by the tribunal. All that we sought in the interim, let them not disturb the tenant. That's all, my lord. In fact, I am also not in possession of the property. Admittedly, they are also not in possession of the property. A single tenant occupies the entire building.
There is already an order to that effect.
In fact, my lord, that's the reason now, my lord, what they are trying to interpret now, because of the dismissal of this order, once again, my lord, they have started to trouble. And the tenant, my lord, is depositing the rentals, my rentals, and as well as their rentals before the court in an interpleader suit. Therefore, my lord, minimal protection, my lord, not to, my lord, disturb during, my lord, the pendency, my lords, may kindly.
Issue emergent notice to the respondent. List immediately after service is complete. In the meanwhile,
let them not, my lord.
Already in order.
In fact, my lord, they will interpret that, my lord. They have been interpreting, my lord. They have been interpreting.
That's a matter. In the meanwhile, in case there is any disturbance or harassment to the common tenant, the appellant is free to place the same before this court.
So great. So great. So great. My lords, may kindly.
We cannot assume that an order of this court will be.
My lords, may kindly make a note of, my lord, this order, so that, my lord.
Yes.
My lords, may kindly observe that there is already, my lord, an order.
It is clear that there is already an order passed by this court that the tenant shall not be disturbed at the instance of the respondents in this appeal. Then say this last sentence.
Yes. So greatly applied. So greatly.
19 Adjournment 20. B.B. Shukmuma.
So you have to respond to on this matter.
Suit for ejectment.
Ejectment would have been restrained with an order passed by the trial court, as against which I am now before this court. Was these agreement that I should use the premises for marriage hall, etc. And the trial court comes to the conclusion restraining me in that regard. The agreement speaks to that effect. I have taken my defense in the defense statement also.
Subleasing, assigning or parting with possession in any manner.
Yes.
Is the
That's the order.
Yes.
I'm not going to, I can't part with the order. But using it for marriage purposes, I can't be restrained.
My lords, you have an objection to that?
Please, my lords, I do. My lords, kindly see the respondents are the owners of the property. There was an oral month-to-month tenancy. There is no written document. The written document which they allege has not been produced in this suit. In the written statement, not a single document is produced. The lease was initially for a car showroom. It was given to appellant number 2. Appellant number 1 is a firm that he has formed along with appellant number 3.
A lease for a car showroom by
Yes.
oral lease?
Yes, oral month-to-month tenancy in the year 2006 by the mother of these respondents. She has since passed away and they are her heirs. They've inherited the property. The car showroom was running. Thereafter, it has been converted into a wedding hall. For the wedding hall, a construction has been put up. My permission has not been sought. The diversion of purpose I have not consented to. On these grounds, I sought to terminate the lease in the year
No license
2023.
is required for a marriage hall?
But it was,
License.
there is a lease agreement which shows that I can use it for the purposes of.
There is no lease agreement, it's not produced. Instead, what the tenant does is, goes and files a civil suit in the trial court, City Civil Court, OS 6896 of 2022, and takes an injunction against me. I'm the true owner. Then, my lords, thereafter, I filed a suit for eviction. And I issued the notice, I filed the suit for eviction. My lords, during the month of Ramzan, both last year and this year, this tenant has subleased the property to set up various stalls. In that wedding hall, they're conducting a business. In spite of an order of injunction restraining them, I have filed contempt applications which are pending because that was after the order. Therefore, my lords, now my humble submission is 2 things, my lords. They have to vacate. They are tenants. There is no dispute that they are tenants. My lords, if they are willing to vacate in a fixed time period, my lords, they may do so. Now the suit is posted for cross-examination of plaintiff witness, my lords, and this order has been operating since the time of the suit in 2023. And it was confirmed, my lords, in February this year. They filed it only now.
Yes.
And he as a tenant anyway cannot do any of these things. So therefore, my lords, my...
Defense at page 58 in my written statement. These defendants put forth the true and correct facts. What I said, defendants have constituted a partnership firm.
Now, where is the tenancy agreement that you
I
rely
can
on?
produce that. I'll produce.
It's
it.
not produced with a written statement in the court.
Produce it.
My lords, he
produced?
can't
Has
produce
to be, has to be
Please, my lords.
produced there. It has to be produced before the
Produced
trial.
it there, I'll produce it here also.
It's not produced. I have filed the admissions and
Also I
denials.
have produced.
In his injunction suit, he produces it. All those are concocted. And that injunction suit is stayed. I filed a memo to dismiss the suit because there cannot be an injunction against a true owner. That has been stayed by this honorable court.
Yes, Learned counsel for the appellant submits that further documents which were on record before the trial court will.
My lords,
be
not in
produced
this matter,
first.
my lords, in another matter.
If it is,
Yes,
if it is not, we are not taking it up. If as a matter of fact is produced there, then we'll consider list after 2 weeks.
please.
If my lords, your lordships may have it after vacation.
Yes, yes.
Yes, after 2 weeks.
Yes.
Very
After
well.
2 weeks will go
Very well.
beyond the.
I'm 2110. 21,
Yeah, date.
Chinnappa,
Kindly pass
21st.
out, my lords. Section 9, Schedule C, third party rights. Marketing service agreement.
Yes, my lord, marketing services agreement wherein your lordship has directed.
Is there any point listing, passing it over today? Can we have it on some other day?
My lord, there's some urgency. We need a stay, my lords, stay of the commercial code.
Yes.
I'll take my chance. Can you pass?
Preliminary hearing, number 22.
Last occasion, your lordships, after hearing the matter,
Mm.
expressed that whether there is any terms of possibility of settlement, anything.
Mm.
My lords, we intimated the parties.
Mm.
Now parties have spoken to it.
Mm.
My lords, my party did not appear.
Mm.
Now she appearing before this court
Mm.
and making an allegation that we colluded together and making an, my lords, I want to retire from this case, my lords. Party is here. She never turned up till today, my lords. Making an allegation without consulting me, my lords. My lords, this is unfair.
What is the?
Coming with another advocate.
Please, just a moment. Yes. Please tell us, is there, ಈ ಕಡೆ ಬನ್ನಿಮ್ಮ ನೀವು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. ಅಲ್ಲ
ಆ ಕಡೆ
ಕಾಣಿಸ್ತಾ
ಬನ್ನಿ, ಈ ಕಡೆ ಬನ್ನಿ.
ಮೈಕದಲ್ಲಿ ಮಾತಾಡಿ.
ಅದಕ್ಕೆ ಏನ್ ಇದು ನನ್ಗೆ ಇವಾಗ ಅಡ್ವೊಕೇಟ್ ಮೇಲೆ ನಂಬಿಕೆ ಹೋಯ್ತು. ಅದಕ್ಕೆ ನಾನು ಕಾಂಪ್ರಮೈಸ್ ಬರಲ್ಲ. ನಾನು ಮತ್ತೆ ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡಿ ಇದು ಮಾಡಕ್ಕೆ ಸ್ವಲ್ಪ ಕಾಲ ಅವಕಾಶ ಬೇಕು ಅಂತ.
I am ready to hand over the file. Till today, she has not come to me, madam.
I am coming from Tamil Nadu, Hosur. I am not here. I am an aged lady. I am 63 years old.
that does not mean that we had asked whether there was any chance of settlement. It is pursuant to that you were contacted. What is your, if you don't want to settle, you can engage whoever you want and conduct the case. Don't make allegations about officers of this court. The lawyers of this court are officers of this court. Why are you making these allegations? We had asked whether there's any chance of settlement. If you don't want to settle, don't settle. Nobody's forcing you to settle any case, but don't make allegations against lawyers of this court without any material. Have you contacted the lawyer?
ಇಲ್ಲ ನಂಗೆ 10 years ಅವ್ರು ನೋಡಿದ್ದೆ.
Then why are you making these allegations? Please don't make allegations against the lawyer. If you don't want to settle, absolutely nobody will force you to settle. You can engage any lawyer you want. This lawyer does not want to continue with your brief. You are free to engage anybody you want, but don't make allegations against counsel of this court.
No information from till to today.
Why did you not?
After this, they have held a settlement with all the landlords. My instructions are that who has referred me the case. She demanded 25 lakhs per acre. They demanded, they are ready to pay 5 lakhs.
Whatever settlement is that they have entered into or attempted to enter into, that is not the subject matter here.
None of the
She does
advocates
not-
were present for that settlement, my lord.
If she did not, if she does not want to settle, she can, it is open to her. Yes.
My lords, I am ready to return, my lord.
Is there any allegation made against you in any of the
No
material?
application is served to me.
Yes, don't copy. Yes.
My name is removed. Let her appear.
The learned counsel appearing for the appellant, writ appellant seeks to retire from the brief and submits that the submissions made by the appellant in person who has appeared before us would make it clear that she does not want to settle the matter. In the above view of the matter, the learned counsel is permitted to retire from the brief. The writ appellant is free to engage any counsel of her choice. List after Dasara holidays.
My lord, later on, my lord, let her not make allegation, my lord, before any other page, my lord.
Yes.
Recorded.
It is, we make it clear that the appellant, that allegations, if any, made as against the counsel are unjustified in the facts of the instant case.
ಬೇಡ ಅಂತ ಅನ್ಸಲ್ಲ ನಾವು I don't
Yes.
want.
That's my name.
Yes, you can file wakalat, anybody you want, or if you want to appear by yourself, all that. If you want to appear by yourself, you'll have to go before the party in person committee. If you want to do that, that also you can do. Otherwise, if you want to engage any other counsel, that also can be done. Now, there is no counsel appearing on your behalf. You can engage anybody you want. Yes, list after.
Please.
Dasara.
R14. I have filed the wakalat lordship to the advocate who was represented at that point of time.
Now it seems that, Your Lordship, that person has given instructions to my learned friend
Before.
saying that I have not given the wakalat.
R20,
R 14.
R14.
I am also permitted to retire from the case.
Yes, Learned counsel appearing for the
R14
14th
ಅಷ್ಟೇ.
respondent is also permitted to retire from the case in view of the
copy, copy.
submissions
ತಗೊಳ್ಳಿ.
made
So,
before
okay,
this court
thank you.
today.
Yes.
Much of it.
List after this. Sir.
Twenty-three, government advocate.
Your Lordship, in the last occasion, had formally told that the appeal will be dismissed because it has become infectious. And regarding the payment, since the government has not taken any steps.
Where is the government?
There,
Just a second. Yes. You're looking for your files? No difficulty.
only for, formally it was adjourned for dismissal. Your Lordship said on the last occasion itself.
Can it be dismissed or are you, on merits you want to make submission? We'll pass it over.
No, it is only a simple issue, Your Lordship.
What
A
is it?
direction was issued for the government to do the work. The government
You need-
followed the.
You want to argue the matter? Yes. We'll hear it. Pass over. Pass over, pass over.
That I oppose, Your Lordship, because this court has
We'll hear
imposed
it.
20 lakhs.
Yes.
Being for just filing the appeal, this court has imposed 20 lakhs for the government to deposit.
24, 12 o'clock. We'll see whether it can be taken up. We'll see whether it can be taken up before lunch itself. Yes.
Number 24, Sanjay Nair.
This is the case where I was, government property was sold to me in public auction. Thereafter, they said that it has been acquired. On the last occasion, my lords, after noticing this one, my lords have recorded. As a last chance, the time is given for government advocate at her request. Otherwise, it will be ordered today. All that I am asking is, in accordance with the judgment passed by a coordinate
Bought
bench.
the property. You've had.
My
enough.
lords, the auction is of the year 2007, my lords.
My lord, subsequent.
By now, even if I wanted to construct a house for myself, the purpose would have been dead by then. Though
What is the-
persons may be
What
living.
is the extent of the property?
1 acre, 12 guntas, my lords.
It is not for construction of a house.
Yes.
1 acre. 12
1 acre was for development of flats, my lords.
Yes.
What I said was purpose would be dead,
Correct,
not the persons.
correct. No, we understand. I was only saying about construction of a house. It is not.
Yes, my
1
lords.
acre, 12 guntas.
1 acre, 7 guntas, only viceroys can build, not us.
Yes.
My lord, after the order of this honorable court, my lord, I have contacted the concerned deputy commissioner. The deputy commissioner has written to the government, my lord. The government has now communicated to the deputy commissioner for refund of the bid amount of 4.5 crores.
Not.
One pause, my lord, one pause. I've not yet completed. My lord, so far as the interest portion is concerned, my lord, there is no communication from the government to the deputy commissioner. May I submit the communication letters? At least it is processed, my lord. It has started. It will take a conclusion in some time.
With regard to the interest.
Interest portion, my lord, they are,
Court has ordered, my lords, in
My lord.
an identical case,
my lord, may I submit, my lord?
coordinate bench has ordered 10% interest.
That also
and
has been communicated by the deputy commissioner in his order, in his letter, my lord. My lord, may kindly turn to page number 5 of my memo, my lord.
No, there are 2 things we can do. We can wait for that
Yes,
decision on the.
I request so.
interest. You can take the amount.
Principal amount.
Principal amount you can take. We'll wait for the decision. I mean, we'll give them some time. If they don't, then we'll go ahead and pass orders.
Very well, my lords, at least today let them pay 4 crores 60 lakh.
Today to pay.
In
my lord.
addition, my lord,
How much time do
My
you?
lord, communication by the government is that I am directed to request you to take steps to return the bid amount of 4.5 crores.
4
That's
crores 60 lakhs is the amount I have
4 crores
paid.
60 lakhs only, my lord. 4
Then
crores
wait and-
60 lakhs.
Yes.
10 lakhs spelling mistake while
Illa,
speaking.
4 crores 60 lakhs is the communication, my lord.
In what time will you give?
My lord, within 4 weeks, we shall pay the principal amount, my lord. Outer limit of 4 weeks I'm asking for, my lord. It may be listed after 4 weeks, a date may be fixed, my lord.
Payment.
I shall once again persuade with the authorities with regard to the interest, my lord. If I do not get any reply, my lord, I'll leave it to this honorable court with respect to the interest. That is what I've already communicated to the authorities.
I have
That
also,
is the best we can do.
I have also paid, my lords. 70,785 was conversion charges. For the government land, after I was declared successful bidder. But kindly, it is a painful thing, my lords. I may be a builder, but that doesn't mean that the government can exploit me like this.
Yes.
And there is no consumer court also for them.
It is submitted by the learned government advocate on specific instructions and on the basis of documents which are made available before this court, that the government has granted sanction on 29/2024 to return the bid amount of rupees 4 crore 60 lakhs to the bidder. It is submitted that with regard to the incidental charges and the interest in respect of the interest on the bid amount, further instructions are awaited from the government. In the above view of the matter, and in view of the fact that permission was granted as early as on 29/2024. Yes. We direct that the principal bid amount be returned to the appellant within 3 weeks from today.
Great.
The appeal shall stand posted after Dasara holidays for the government advocate to make a last effort to get instructions with regard to the interest and incidental charges.
A
And
date,
the
my
last
lords.
week of October.
Yes, even the 28th or 28th.
Obliged.
Till then interim order be extended.
Yes, here 3 weeks, the amount.
Very, very well, my lords. I will,
4 crore 60 lakhs will be refunded within
3 weeks.
The
Because
incidental charges and
29, the,
incidental charges and
interest.
we'll say 4 weeks.
please.
4
3
weeks.
and-
No, because we are listing it immediately thereafter. In the 4 weeks, let them pay, because 29, they've only just ordered.
Very
29.
good.
Yes,
I leave it to,
yes,
at last I got after so many years.
yes. The rest, if you don't, instructions will direct interest. Interest has to
That
be
I've
paid.
already communicated, my lord. It's already
Yes.
communicated. The decision has to be taken by the government.
Yes.
Twenty-five, Prashant HS.
Lords appearing for the appellant. But Lordships have already granted an absolute interim order in the matter. Matter requires consideration.
Is it immediately after?
Lordships.
We'll have it immediately after the,
Contesting respondent is the BBMP minutes and private party.
26, government advocate.
25, we can have it after.
I'm not, we are government is. not-
Government advocate.
Okay. Yes, notice is served to everyone.
Notices are served minutes. The service is complete.
Yes.
Please minutes.
26,
In this matter, my lord, the state had taken a contention that it is within 18 kilometers radius. My lords wanted,
They said
Yes.
they will
yes.
take instruction as to what action they have taken in respect of other 64
may,
grantees.
may I file a memo, my lord? I'm filing the. I'm filing the communication. My lord, at document number 1, my lord. At page number 3, the translation is at page number 10 of my memo, my lord. This is dated 7/7/2022, my lord. My lord, after the direction of the learned single judge, my lord, thereafter, my lord, so with regard to all the other grantees, it has been referred under 108K, my lord.
Oh, it has been.
It has already been referred, my lord.
Yes.
My lord, the page number 12 onwards, my lord, is the documents which have been submitted. That is the application.
Let us just go through this.
Please,
page
my lord,
number.
may I read, my lord?
Yes, please.
English translation, may I read?
Yes.
With regard to the above subject, Shri Mare Gowda, son of late M. Ramaya, has submitted an application to this office for carrying out Podi-related works of the land bearing survey number 39, Meenankunte village, Jala Hobli, Yelahanka Hobli, totally measuring to an extent of 1 acre 30 guntas, as per judgment dated 24/1/22, passed by the Honorable High Court of Karnataka in WP number 20722 of 21. Therefore, since the above said land falls within 18 kilometers, therefore it's falling within the jurisdiction of BBMP, and therefore accordingly a proposal was sent to take appropriate action under Rule 108K of the Land Revenue Rules. Therefore, as per the judgment passed by the Honorable High Court of Karnataka for taking appropriate action under Rule 108K of Land Revenue Rules for carrying out PODI related works, the records pertaining to the original grant certificate persists page number 1 to 438. The entire records of Tippani number 1 to 10 are enclosed herewith for the kind reference. Persists of office records pertaining to original grant certificate number so and so for filing of cases under Rule 108K to be filed in the Court of Honorable Assistant Commissioner, Bangalore. They are all the other grantees. ma'am.
If you are taking action as against the other grantees after the judgment,
My lord, Rule 108K. My lord,
how can that be after the learned single judge finds
please, ma'am.
that it is belated, that nobody else has been proceeded against, and after that you are seeking to settle? Cannot.
My lord, but section 94A is very clear, my lord, under where the land falls under 18 kilometers of the municipal limits, my lord.
When?
My lord, that was in 1994, my lord.
Yes,
1997, this land could not have been granted. So for that reason, it is referred to the Assistant Commissioner for,
94.
please, ma'am.
What was the distance? That is also
That
considered.
was
Yes,
only up to Hebal. That was only up to Hebal. After the
From
My lord,
BBMP.
1994, I don't know if it was up to Habal, I'll take instructions, my lord. But section
that is what is started
94A,
by Learned.
Is that aspect considered by the learned
Yes,
single judge?
Yes, my lord.
no, my lord,
I
that
request you-
it was up to Hebal was not considered, my lord.
No, that is considered.
It is only, my lord, at the relevant time,
At the relevant time when the learned single judge was considering the issue, you had not admittedly not issued notices with regard to anybody else.
my lord, this information was also produced before the learned single
In
judge.
respect of some of the grantees, they have already ported the land.
Page number 15, my
I will
lord,
place it on
of the
record.
writ appeal papers, page number 15.
Hmm.
The learned AG has filed a memo dated 21/1/2022. Last 3 lines, my lord.
Hmm.
Along with the communication made by the respondent Tahsildar to the Assistant Commissioner for cancellation of grants.
Hmm.
However, the learned counsel for petitioner submits this information is not made available.
Relevant, that is not the question. As on the date when the orders were passed, the order impugned was passed. There was nothing as regards anybody else. You've taken up this contention only with regard to the petitioner, the appellant here. I mean, the petitioner here in
The respondent here.
the respondent here. Therefore, the learned single judge found that there is no material before this court showing the prompt action taken consequent to the circular dated 18/9/2014. That was the finding. And that pick and choose action cannot be taken. What are we considering? We are considering the correctness of the judgment of the learned single judge. As on the date when it was being considered, there was nothing to show that apart from the petitioner, anybody else had been proceeded against. You are relying on a circular dated 2014. Till 2022, you do nothing.
Yes.
That was the ground on which the learned single judge allowed. After the judgment, that you have taken some action, will not make any difference.
Lord, in the last date, since I had argued, my lords are
But
directed
you
at least
cannot
to
rectify-
show documents
Correct.
whether we have initiated action against the other 64 applicants.
Had taken action against the other 64 before the judgment of the learned single judge. If there was something, probably that could be argued, that we had taken action against others also. Even at the time when the learned single judge considered it. Not so. After the judgment, you cannot rectify what the learned single judge finds as against. Cannot be done. Cannot be relied on for the purpose.
But my lord, section 94A is very clear, my lord, within 18 kilometers rate. It's not only on the basis of circular, my lord. Circular is based on section 94A, subclause 4, my lord. My lord, that provision cannot be overcome, my lord.
Land Reforms Act.
May I read section?
Yes, please read.
Nothing in section 94A, regularization of certain cases of unauthorized occupation, constituting committee, etc. Subject to such rules as may be prescribed, the state government shall, by notification, constitute for each constituency of legislative assembly a committee consisting of such number of members not exceeding 5, of whom one shall be a member of Legislative Assembly for the purpose of grant land under subsection 4. Subsection 2, the Tahsildar of the concerned taluk shall be the secretary of the committee. Section 2A, if the state government may, if it is of the opinion that it is necessary to constitute one or more additional committees for the taluk for purpose of grant of land under subsection 4, consisting of such number not exceeding 5, as may be prescribed, the state government shall nominate from the members of one of them as chairman and another as secretary of the committee. When an additional committee is constituted, the deputy commissioner shall determine the jurisdiction of the committee and the additional committee and transfer the pending applications to the respective committee. Subsection 3, the committee or additional committee shall follow such other procedure. Subsection 4 is relevant, my lord. Nothing in section 94 shall prevent the committee constituted under subsection 1 or the additional committee constituted under subsection 2A, but subject to the rules as may be prescribed, if any, to grant to the person liable to be evicted under that section the land which he had unauthorizedly occupied prior to the 14th day of April 1990, hereinafter referred to as the said date, or any portion thereof, if he satisfies the prescribed conditions, including the extent of land held and unauthorizedly occupied by him, and makes within a period of 6 months from the date of commencement of the Karnataka Land Revenue Amendment Act 1990, hereinafter referred to as the Amendment Act, an application for such grant in such a form, along with such fees as may be prescribed, and on payment of such amount payable under subsection 5, provided that the land so granted together with the land already held by such person shall not exceed 2 hectares of D class of land or equivalent thereto.
2 hectares.
Please, my lord. That is
Here,
under
extent is 1 acre 30 gunta.
1 acre.
1 acre. Provided further that no land shall be granted in the areas lying within the limits of cities and city municipalities specified in column 2 of the table below and within the distance from such limits specified in the corresponding entries in column 3. Serial number 1, Bangalore City under Karnataka Municipal Corporations Act, 18 kilometers. My lord.
Therefore, now what we are considering is the orders dated 8/9/1994 and 22/7/1998.
Please, my lord.
Therefore, it has to be within those 18 kilometers from the.
As on the date of the grant.
As on.
The date of
those
the
dates.
grant.
Yes.
Grant was in the year on it was granted on 11/11/1997, my lord.
11/11/19.
Please, my lord. Survey number 39, 1 acre 30 guntas, granted in 11/11/1997.
What was the distance from the
Bangalore
city
City,
limits
as on 1997.
Yes.
May I very?
I request your lordship to kindly take the internal page number 6 of the learned single judge's order.
Yes.
In the beginning itself.
Yes.
Moreover, it has been submitted on facts that the lands in questions were never within the restricted distance. Since in the year 1994-1998, the jurisdiction of the corporation, which was then known as Bangalore Mahanagarapalike, was only till Hebad. And whereas subsequently it has grown with the addition of many villages, and the jurisdiction is now expanded much beyond what was the boundaries during the year 1994-98. All these aspects will have to be taken into consideration. On facts, the court has come to the conclusion that it was only till Hebad. Later it was expanded. Now, as on that day, it was beyond 18 kilometers.
Therefore, this writ petition stands disposed of, granting liberty to the petitioner to file an application online, and which shall be, the competent authority shall also take note of the.
But all that I had asked was to fix the boundaries of my land. If they want to take action, then let them
Therefore,
take.
if you have a contention that it was within 18, it is only if it is within 18 that you can proceed. But you can, even though the direction is not to,
my lord,
it's not a positive direction.
His case is still pending.
All
My
that
lord.
the court has
Document
said,
number
fix
2.
the boundary and
In my memo, my lord, I have produced the order sheet. Document number 2. I have produced the order sheet, my lord.
Therefore, what stands in the, there is absolutely nothing wrong in the directions now issue. How are you aggrieved? That we don't have to consider what was the extent of the Bangalore City Corporation as on that date. Just open for the, who's directed? Assistant Commissioner to make that verification.
My lord, that observation may be passed in this order, my lord, that nothing comes in the way of the case which is pending at page number 23, document number 2 of my memo, my lord. That is the case against, under Rule 108K, which is initiated against the respondent herein for cancellation of grant.
No, if as a matter of fact,
Please,
it is
madam.
within 18 kilometers.
My lord, that is a matter of
The
fact.
108K goes.
My lord, if it is a matter of fact before the assistant commissioner in this case, my lord.
Exactly.
Please, my
That is
lord.
only
If
against
that
me,
there is,
insofar as 64 per
There
other
are two
person.
ways of doing this.
Please.
Either you can tell us what was the extent of the corporation as on the date when the grant happened in 1997. If that is
Well,
done, that
well,
would be the end of
In
the.
fact, the 18 kilometers to be fixed as on the date of application, not on the date of the order. There are several judgments on this point. I'll place it on record, Miller.
Either that or that issue can be looked into by the assistant commissioner. We won't say anything about the one not, because after the directions issued by the learned single judge, whatever has happened, we cannot take note. That should not be. We'll say that this will be decided on the merits after hearing the parties and considering
Hello.
factually what the extent was at the relevant time.
my lord,
Whether
that
it
matter is already pending, my lord. I have produced the order sheet at page number 23.
When did it become pending? When was it, when was the action taken? After the judgment of the learned single judge, we will not take note of it.
It is after the order of the learned.
We can't take note of it. After the learned single judge finds that there is no material, no action taken. Which is.
19/7/22, my lord. 19/7/2022 appeal is filed.
This is 24/1/22, the judgment.
Yes, ma'am.
Apparently as a counterblast. Cannot be, that we will not take note. This is not unfair. If we say that that will also be taken note of, just because you had not taken any action. That the learned single judge said that there is no action as against anybody. Now you take action against everybody. We don't propose to say anything about that. This issue you can take note of.
My lord, but this case is pending, my lord, that at least it may be decided without any.
We cannot say that. Because as a matter of fact, if what is stated by the learned single judge is as a matter of fact correct, if it is beyond the 18 kilometers as on that date.
And may I take instruction so far as only that one point is concerned, my lord, whether it was within 18
This
kilometers?
is all that has been directed. That also you're free. Therefore, this writ petition stands as post of granting liberty to the petitioner to file an application online seeking 40 duress work, and competent authority shall take action as expeditiously as possible, at any rate within 3 months. Competent authority shall also take note of the observations made here and above, shall not decline to process the application, contain the work.
I understand, my
To
lord.
complete the work.
This is all what has been directed. With respect to his application, we will have to produce, my lord. We'll have to proceed, my lord. But so far as our proceedings, which we have already initiated under 108K,
You had not already initiated.
I agree, my lord, now which is initiated, my lord, which is already pending before the assistant
First
commissioner.
decide this and then go ahead with, if as a matter of fact, you find that it is, you can decline.
That
his
shall be
application,
decided independently on merits may at least be observed, my lord.
It is only if this can be declined on the merits that the other issue arises. The cancellation of the grant arises. If as a matter of fact, you find that this has to be allowed on the facts of the case, that would be the end of the 108, your 108K applications.
My lord, that's for that reason only I have filed this appeal, my lord. I shall submit whether it comes within 18 kilometers as on the date of the application only.
The first thing you should do before issuing these notices under 108K. After the learned single judge has held this, has given these observations, issuing those notices without
Pending against this respondent before the assistant commissioner.
which is initiated after.
I understand, my lord, after the,
Therefore, we are saying that if you had not verified this before proceeding, that amounts to the violation of the directions of the learned single judge. Prima facie.
my lord, if Hodi Durasti application is submitted, my lord, we shall, as per the directions of this learned single judge, we shall have to consider his application, my lord.
Absolutely.
For that. My lord, my application which is pending before the assistant commissioner, no observation.
It's not pending at the relevant time.
It was not, my
what-
lord.
Therefore.
It
that-
is, proceedings are still pending. At least we may be given liberty to litigate there on the merits of the case, my lord. With regard to 18 kilometers as on the date of the application.
That this application as directed by the learned.
Which application?
Decide that on his application as directed by the learned city. When there are directions by this court, you cannot get over them without first, otherwise there should be a specific finding that it was as on the date of the grant or the date of the application, whichever is the relevant date, it was beyond, I mean, it was within 18 kilometers. Without such a finding, this issuance of those notices itself, according to us, is against directions of this court. You cannot sit in appeal over directions of this court and issue communications thereafter. If as a matter of fact, you have facts on your side, then it is for you to reject this application on that ground. And
I
then
understand.
proceed.
I understand.
Then proceed, not, you can't get over directions of this court by proceeding without, we will not say anything about your 108 applications.
I
As
got
a
the
matter
point.
of fact, we find that they are not valid.
We shall consider his application on merits, madam.
Must be considered on the merits. Heard both sides. In view of the averments made on both sides. We are of the opinion that the learned single judge by the judgment had only directed the consideration of the application to be made by the petitioner or made by the petitioner in accordance with law, full stop. Though the learned government advocate relies on section 94A,
94A, 94(3),
94A,
94A3.
94A, 3 and 4 of
4, madam. 90, Karnataka Land Revenue Act, madam.
of the Karnataka Land Revenue Act. And submits that
Subclause 4, my lord, not 3. Proviso, second proviso to subclause 4.
94A, 4, second proviso.
Please.
In the light of the clear directions, in light of the observations made by the learned civil judge in para 6 and 7 of the judgment, we are of the opinion that the question whether the land of the petitioner was within the objectionable distance as per the said proviso is also a matter, at the relevant time, is also a matter which could be considered by the competent authority. In the above view of the matter, we are of the opinion that there is no merit in the appeal. The appeal failed, same is accordingly dismissed. The question of distance from the limits of the BBM of the Bangalore City Corporation at the relevant time can also be considered by the competent authority in accordance with law, while considering the application submitted by the petitioner as directed by the learned civil judge.
Time frame maybe fixed, madam. Already
Time
there was a
frame.
time frame and they have.
2 months.
Please.
Yes, the respondents, I mean, the appellant shall carry out the necessary steps as directed by the learned single judge within a period of 2 months from today.
From today.
Delay is condoned. There's a delay. We had not condoned the delay. Delay shall stand condoned. This is the final order of the appeal. Yes. Delay usual orders. Hearing on IA, number 28.
May I please? I
28
appear
is
for
early
the,
hearing.
yes, I have made this application.
Yes, can we hear
I-
it on some other day?
It's a short question, very simple question.
Yes,
Matter relates to recruitment.
yes.
The appellant is employed.
Mm.
I am unemployed. He is happy with the interim order and dragging on the matter without allowing the recruitment to take place. All that the learned single judge has done is,
Mm.
he found that the selection was vitiated by bias.
Mm.
Because
Mm.
even prior to the interview, the appellant started celebrating his status as a newly recruited person. and more importantly, giving a red salute to his prospective boss. He described it. So all this material was produced. Personal bias was alleged. Official bias was also alleged. On both counts, the learned single judge has found favor with me and has set aside the recruitment and directed a fresh recruitment to take selection to take place. Then I was on top of the list so far as the written test is concerned. At the interview, the scales were tilted in such a way that I was reduced to 0.5%, whereas he was given.
So therefore, the learned single judge directed the selection to go on from the interview stage?
Yes,
From
yes.
the interview stage?
That is all the direction.
Kindly pass over, madam. 6 pass over. Senior counsel is held up in the other.
That's all the direction issue.
Yes, pass over today.
Otherwise, your lordship may fix a date.
We'll make an attempt today itself.
Yeah,
Pass it
I'm
over.
ready.
After 2:30, we don't know whether it will be possible.
After
Anyway, let us
2:30, I also have a.
Can we have it on some other day?
Yeah, some other day, tomorrow, day after. Because this is all the question.
Yes. But
On Friday, if it is called
difficulty is only for time.
on Friday, if it is called on Friday, there should be.
Matter of gram Vidyut Panchan. That GVP's matter is listed on Friday.
Or Monday.
Can we have it immediately after the Dasara holidays?
My only problem is this: I am without employment, and he is also placed under suspension. He can. He is already placed.
He also is in a hurry to find out one way or the other.
In fact,
Posting. We'll have it immediately after the immediately after the holidays. We
Anyway,
realize the difficulty. The only problem is it must be heard.
I leave it there. I can only plead for an urgent hearing.
16th.
Very well.
For preliminary hearing.
Yes, preliminary hearing. It can be disposed of at this stage.
Please be ready on that. Will not be adjourned.
Please.
Yes.
Interim order make it.
Yes, till then.
Grateful.
Yes.
29 adjourned. 30.
Item 30.
I appear for the I appear for the first respondent, after vacation. Please, Malad. They may be directed to serve a copy of.
There is a 36 days in
Please,
filing appeal.
Please,
Can
Malad.
that be condoned? And we'll.
No, Malad,
list
have
it.
not been served with a copy of the IAS, Malad.
The delay continuation also you have not been. served.
No, only the appeal memorandum has been
For
served.
Arban, you are appealing.
Respondent.
This order. To accepts notice on behalf of the.
No, Malad, no. I only appear for the respondent number 1. I only appear for the first respondent.
Private party.
Yes, issue notice.
Please, Malad.
Please serve a copy of the IAs, including that for continuation of delay. Not today comes. Yes.
Notice is ordered.
Please, if you don't want, then we'll have it on some other day. Yes.
30.
If you don't want notice to be issued, we can be on some other day. Osa, yes, on some other day.
31, government advocate.
My lords. As the matter pertains to, there's a delay in the matter, my lords.
158 days.
Madam.
Notice has to go.
My lords.
Yes, notice.
32.
46 days delay.
46 days minutes.
Notice has to go.
No, the state is on the other side. Your lordship may direct them to accept notice.
Can
It's
the
all only
state
instrumental.
accept notice on behalf of the respondents?
My lords.
Learned government advocate?
Lords, national highways, lords, some standing down.
Lords, there will be a,
You must tell us who is the standing counsel who will accept notice. We cannot say some standing counsel. Issue notice, take out notice to the respondents. The appellant may also serve the notice by serving on the learned standing counsel.
Please.
And inform the registry so that name can be shown.
Please.
Yes. Yes.
33.
I appear for the appellant.
Our Research Institute delay. Notice has to go.
Malad, I've already, I'm appearing for the respondents. We have already filed a counter to that effect. On the last occasion, a better affidavit was filed by the appellant, my lord. On the aspect of delay, I leave.
72 days.
Yes. the better
72
affidavit is
days, ma'am.
Actually better.
What?
The better affidavit is actually better.
Yeah, we made improvements.
Yes, heard the learned, IA number. One is the 1 of 2024. We have perused the affidavit filed in support of the application and heard the learned counsel on either side. In view of the averments in the affidavit filed, there will be the delay of 72 days in filing the appeal shall stand condoned. List for admission.
Admission. My lord, interim order is there.
Interim order is already there.
My lord, not to precipitate, my lord.
Lord, they have filed a stay petition.
Can
Your
we have
lordship
this-
will have to hear the.
Can we have this immediately after holidays?
Very well.
Please, till
List
that
after
time, let them not precipitate.
May I
holidays?
request for 28 October,
28, yes.
28.
List on 28/10
28.
for admission.
Yes, madam.
28/10 for
Very-
admission.
very-
Till such time, the further proceedings shall not be precipitated.
Please.
34, Siddharth Kitchen.
So I appear for the appellants. Senior.
31 days. Delay.
Yes.
Notice.
35, Ajesh Kumar S.
My lord, for the appellant.
34 days.
Yes, ma'am. My lord, the
Yes.
order, my lord, was passed on 28/6. We filed the appeal on 28/8, my lord. I mean, order was uploaded, certified copy was available on 28/6. 28/8, we filed it, my lord. So it was within time. Office had raised an objection. Therefore, we filed a condemnation.
You appear for the response?
Aviator, ma'am.
Wait, we can have it on some near date.
But the
Seen
thing
the
is, the matters before, the section 8,
Hmm.
defendant's appeal, application was rejected.
Hmm.
The trial court took a view, my lord, that because the lease agreement is terminated, arbitration agreement comes to an end based on a judgment prior to 1996. That's the view.
No, my lord.
My lord, this
If
is
he's
a
pressing for stay, my lord, I seek for a passover, my lord, being led by a senior counsel. He's held up in court all 8. I request for a short passover.
No, it is not,
1 and 2. Notice to 1 and 2 ನೀವೇನ?
Now, I'm on caveat, my lord.
For both.
for both. One
For
and
both.
In page 49, my lord, para,
Just a moment, just a moment. So,
matters tomorrow, my lord.
My lord, I just seek for a short passover. my lord.
yes,
Short passover, please,
12:34,
please,
Passover. Let's
please.
see.
Grateful.
If it's not taken up before lunch, then we'll have to,
No, my lord,
yes.
please.
36. Pa.
Niche.
I appear for
Acquisition.
please, Miller. I appear for the appellant. Your lordship, an interim order was granted on 29th August, subject to deposit of 50% within 6 weeks. We have communicated the same and it will be deposited by this Friday, your lordship. And the only pending application that remains is dispensation application for dispensing with the certified copy of the arbitral award at Annexure B. So, your lordship, the only issue in controversy is the nature of land. Nature of the lands, because the lands have been treated as non-agricultural. So may I just request a date for final
You've
hearing?
produced other copies. It's only the certified copy that needs to be
Needs
dispensed.
to be dispensed with. I have produced a copy because the impugned judgment, there is certified copy.
Yes.
If a date can be fixed for final hearing, the matter can be posted because
Yes.
delay has already been condoned, your lordship.
IA 1 of 2024. The
36.
IA 1 of 2024, heard both sides. The IA is allowed. List the appeal for hearing after.
Time. Dispensation allow again.
Listed for admission.
Ah.
Kindly list after the Dasara holidays.
29th, ma'am. This one 29.
I think she means 27.
29 Sunday ಬರುತ್ತೆ.
Monday. Monday.
What is Monday? Why? What is the urgency? We'll have it after the break, 29,
21/10.
21.
21/10.
Yes.
Passed over.
Yes.
Till number 21. Passed over matter. Then Chinnappa.
Myla, please hand up. So, notice. Kindly pass.
No points. Notice. 23.
Hang on, this is the government appeal with regard to the effective date of the sixth pay commission. Now, your lordship last time asked me whether the other appeal, that is, WA 265 can be made as instructors. My humble submission is it cannot, because it stems from the fact that when is the implementation of the sixth pay commission? So now we are looking into this appeal. The important issue, my lord, is if I can take your lordship to one order of your honorable lordship. To give you a brief background of the case, my lord, what has happened is in both these appeals, right from the year 2018, the learned counsel on the other side for the respondent has been making representations and filing petitions stating that there is no parity between the pay scale given to teachers under the UGC and the respondents are pharmacy professors and assistant professors coming under the AICTE, which is two different streams. So what is governed, of course, UGC and AICTE work under the same thing wherein they look into the overall as to how these colleges and technical institutions work. They only oversee.
They are pharmacy professors.
Your lordship, may I make one correction in this? I have quoted in my other writ petition, there was a blunder in considering UGC. That in the subsequent it is AICT. I have said, because what happened is I have filed nearly 4,000 writ petitions. At that time, UGC and AICT arrears were not being paid. So by mistake, inadvertent mistake, I brought UGC into picture. And what has happened is, though the UGC and AICT arrears were to be paid as per the sixth revised pay. So there was a consent judgment to consider my representation and pass the order. The government considered my representation. Why in the contempt petition, I can't make any wrong submission. In the contempt, my judgment was not considered, so I instituted a contempt petition. In the contempt petition, the government clarified that they consider my representation by passing an order saying that the government will be financially overburdened to pay the money. So that I was given liberty to challenge that order. That liberty was challenged in the subsequent writ petition, and the learned single judge quashed the order passed by the government. So now, after the contempt was initiated against this thing, they filed a application to reopen the writ appeal 258, which was dismissed in the year 2020. So your lordship had rightly concluded on the last occasions, since the government has considered the representation, the appeal does not survive. So your lordship wanted to dismiss the appeal because they have considered my representation. Rightly or wrongly, the representation is being considered, and even the writ appeal was also dismissed. After 3 years, they filed an application to reopen the appeal, which was dismissed. So this court had an opinion on the last occasion also to dismiss the writ appeal.
Yes, if I may just explain the background of the case, my lord. Now, if I take your lordship to 1185 of the writ appeal for a moment, the learned single judges 1185 of 2022, the writ appeal. There are two writ 58.
Your lordship, first they have to succeed in 258, and then they have to, because
argue her case. Please, we'll hear you.
There are two writ appeals, my
Yes.
lord. One is 258,
Hmm.
wherein it was for consideration of a representation,
Correct.
right? We leave that aside, park it for a bit. If we look into 1185 of 2022 at 22.3, if your lordship can just take that writ petition, writ appeal, my lord.
Yes.
Now, in that writ appeal, my lord, the learned single judge's order, the impugned order is at page 35.
Hmm.
Now, over here, the learned single judge
Hmm.
passes the impugned order.
Hmm.
If I can read from page 49, para 3, the learned AGA, however, submits that in case some of the petitioners, the payment have been made by the state, and therefore, if the petitioners are permitted to give representation once again, the same will be considered and arrears of salaries will be paid. Then it looks into whatever the judgment, and then consequently, these writ petitions stand disposed with the specific direction to the Department of Health and Family Welfare government to pay the arrears of salary and other emoluments as per the scale fixed by the AICTE from 1/1/2006 to 31/10/2011. Now, my argument before your lordship is, we have been giving the payment as per the Sixth Pay Commission from 1/11/2011. That is the government order which gives effect that the Sixth Pay Commission the effective date will be 1/11/2011. However, the claim of the respondents herein is claiming arrears, that is from 1/1/2006 to 31/10/2011. My entire argument before your lordship is, this is impermissible. Firstly, because by virtue of the learned single judge's order, he hasn't set aside the government order, which was prayed for by the respondents in this writ petition. So the mother document, that is the government order by virtue of which the implementation of the Sixth Pay Commission comes into light, still holds foot. And that has been observed. My lord, if your lordship for a moment now sees the order passed by your lordship on 31/7/23 for a moment. In writ appeal 258 of 2020. Both of it have got merged because just for a moment, if your lordship sees your lordship's order dated 31/7/23.
Yes.
My lord, in this, from the para 4, I shall read. Per contra, learned counsel for respondent 1 and 2 would submit that pursuant to the directions issued and the directions having not been complied with, they preferred contempt petition, and in contempt proceedings, the appellants have produced an endorsement rejecting the representation, and the contempt court was pleased to close the contempt proceedings. Now they're talking about 1185. As in, sorry, this petition wherein it was considered, this 250.
By reserving liberty to the respondents to mount a challenge. That is what they did by filing the subsequent.
The respondent 1 and 2 are arrayed as petitioners 4 and 5 in the aforesaid writ petitions, and the learned single judge has been pleased to quash the endorsement. The learned counsel for respondent 1 and 2 would take this court to para 3 of the order of the learned single judge rendered in so and so, which reads, which I just read just now, my lord. AGA, however, submits in case petitioners, the payment has been made by the state. Therefore, if the petitioners are permitted to give a representation again, that apart, it is seen that the learned single judge has placed reliance on the ruling involving teachers who were discharging duties in technical institutions. The respondent 1 and 2 herein are teachers retired in pharmacy college. On perusal of the order, we find the notification, government order, that is the mother document, dated 17/5/2012, has not been held ultra-virus, illegal, and the directions have flown independent of this notification. So there is where the learned single judge erred. And all these writ petitions that come about, stems from the implementation seeking for arrears of the 6th Pay Commission.
17/5/2012 says that the arrears are to be given from what date?
Okay, now we'll go into that, my lord, the notification. The notification, my lord, if your lordship sees 1185, we have filed additional documents.
On
Additional documents on 4/1/2023.
4/1?
4/1/2023 in 1185. Now, in that, we have the AICT order. As in, sorry, that is from where the government order stems from this order. So I will just take your lordship through this because your lordship last time also asked me if the AICTE is, it's the parent that looks into all this, and if the AICTE has mentioned an effective date, you have to comply with it, and that's it, period. So I'll just take your lordship through that for a moment. In that, my lord, the effective date applicability is at page 24. Now, over here, clause 3, my lord, at page 25 on top, that Roman small 3, where we are talking about applicability of the scheme. 24, 25 page.
You don't see such page numbers here.
Or we can look into, the same document is there in 256 also.
No,
56.
whichever. Yes, tell us what does it say?
Yes, I will just mention.
Yes.
So 256, it's at page 168, if your lordship finds it. Now, in that, the small 3, it says this scheme, if your lordship could just look into it.
The scheme shall come into force.
Applicability of the scheme. At page 168. And then 169, the scheme does not extend. We are not looking at that. We are looking at the next one. The scheme may be extended. Your lordship. (169), my lord. This scheme may be extended. So the what I would like to stress on is the use of the word may be extended to all technical institutions. So it may be extended to all technical institutions. So each technical institution is different. So you have engineering, you have polytechnic, you have various.
The position is settled that
yes,
you can either accept it.
Yes, in full or not. Correct. I'm with your lordships on that. I'm just saying that there is a discretion over here for the institution to look into it and then follow it in toto.
He may be extended to all technical
institutions coming under the purview of the state legislature, provided the state government wish to adopt again. So there is this discretion given. Now, my lord, after having taken your lordship through that, I would like to just take your lordship through the various government orders that emanate from the
Is it your
UGC?
contention that you chose to accept it only with regard to technical institutions and not to pharmacy institutions?
Your lordship, may I give clarification?
The thing is, under AICT, there are different technical institutions. So you have engineering, you have polytechnic, you have architecture, and you have pharmacy. So engineering had given it on a particular date, the effective date was a particular date. Pharmacy chose to adopt it on B particular date. But we have adopted, but the date is different. And that choosing of the date of effective date is left to the discretion of the state is my humble submission. Whether it is engineering, whether it's
To accept because
yes,
there is the Supreme Court says on identical situations, AICT and UGC, there is a scheme.
Yes.
The scheme says that this will be the pay scales. These are the pay scales that you have to pay. 80% of the expenditure for meeting that will
Yes.
be paid by the
Center, which is
center,
for a particular period only.
whatever.
Yes,
It will be paid by the center.
yes,
You can decide whether to implement the scheme or not.
yes,
You can decide that
yes,
the scheme cannot be implemented.
yes.
Therefore, if you're implementing the scheme, then the scheme is taken as a whole.
The scheme is taken as a whole, but
The
my
scheme-
only submission is,
When you're taking the scheme as a whole,
yes,
date of implementation also comes with the scheme.
yes, my lord. So
The
my only
revised pay-
submission,
Just a moment.
yes,
The revised pay and revised dates of Diana's allowance under the scheme shall be effective from 1/1/2006. The revised rates of all other applicable allowances such as home rent allowance, transport allowance, children's education allowance, and non-compounded advance increments shall take effect from 1/9/2008.
please, my lord.
Payment
Yes.
of arrears up to 40% of the total arrears shall be made during the current financial year 2009-10. Undertaking shall be given from every beneficiary, etc., etc. Therefore, the dates on which the scheme is to be made applicable, that also is a part of the scheme.
Yes,
You cannot
No.
accept the scheme and say that we accept the scheme, but we'll get the 80%, but we will make it applicable only from subsequent dates at our discretion. That discretion is not available is what the Supreme Court has stated in several judgments.
No, my
Unless
lord.
You can tell us otherwise.
No, for instance, my lord, I have one judgment which is with regard to,
I don't
UGC.
recollect judgments.
Right, no,
Oh,
no.
no. Kalyani
I know,
Madhavannan.
In Kalyani Mathivanan, it was clearly said, they can't,
They cannot choose the date.
yes.
If you accept as a whole.
And even Justice Nagaratna recently has held the same, that they can't, but what has happened, Your Lordship, since I am handling this case from a long period, what has happened is it's started with Jagdish Prasad Sharma case. In Jagdish Prasad Sharma case, what happened is there was rippling effect throughout the country. Some state implemented, some state did not implement, some state implemented before AICT passed the regulation. So in order, the government that time thought they want to gain the political gain. They said that they are given liberty to such states to either adopt or implement. But Jagdish Prasad Sharma subsequent para said that those states which implemented AICT and UGC regulation should follow. This part was omitted, unfortunately, by most of these courts, single judge judgment, and now which I am taking, and the matter is now also to the Supreme Court. There is a special bench constituting on that aspect.
The only question is we cannot close it as having become infractors. We'll have to give them
Yes.
a judgment. on
No,
the
I
merits of the
just
matter.
only clarified.
Please, government advocate, please will you look into the judgments as well?
Please, I just have one and two judgments. If your lordship can just kindly look into this, because of the paucity of time, I haven't been able to do my thorough research. But however,
The questions of law in both UGC and AICT, the
Issues-
propositions are the same.
same.
It is whether you can accept piecemeal,
Yes.
whether you
No,
can,
I'm not saying piecemeal at all,
whether
my
you
lord.
can accept piecemeal, whether you can accept with different dates rather than what is.
So my only submission is, my lord, with
Lordship,
regard to.
may I
Jagdish
submit
Prasad.
one?
Yes, in that,
Jagdish Prasad.
yes, in
Yes.
that para
Hmm.
71.
Hmm.
However, in the instant case, the said questions do not arise inasmuch as mentioned above, the acceptance of the scheme in its composite form was made discretionary. Therefore, there is no compulsion on the state and its authorities to adopt the scheme. The problem lies in the desire of the state and its authorities to obtain the benefit that is different. So basically, we have the
Jagdish
discretion.
Prasad was with
and-
regard to retirement age.
Right.
There it was found that.
Only
the
regarding age, it was.
retirement age is something for, you can either, the scheme has to be adopted in its, either
No.
adopted or not adopted in its entirety.
Yes. So my
The question of retirement age, it was held that That was something beyond the scope of the fixing of the standards of education. It is a service matter and it is for the states to decide.
My submission, my lord, is that the implementation by the state of Karnataka with regard to pharmacy professors and assistant professors was from 1/11/2011. For UGC, it was in 2006. Now, each department, my lord, if my lord hears me out for a moment, my argument is with regard to each department, each teacher, each assistant professor, the qualification, the responsibility, the scope of work is looked into, and then the implementation of the 6th pay is given.
Cannot be.
Because UGC teachers are, it
is not us saying it. The apex court says it cannot be because where is the constitution?
Even the act says so, because the act is also, they say that it should be in total. They can't have a piecemeal. That is what your lordship has right. Even the AICT Act I can provide, which says that they can't.
Which is the entry in the in Schedule 7.
Entry 66 and entry 25 in list 166.
Coordination, determination of standards and institutions for higher education or research and scientific and technical institutions. That is totally in the union list. Once the regulations are framed, those regulations and list amount to making that an occupied field, the state government cannot deviate.
And in conflict, union government prevails. That's what even Mativannan has said. In conflicts of law between the state and...
Please, counsel, please let us look into the judgments of the apex court as well. You don't have the, as far as prima facie, unless you can show otherwise.
My lord,
don't have the leeway to say that we will implement the scheme, but not from the date that the scheme says, but on a different date.
My lord,
that position appears to be covered on all fours against.
Because pharmacy professors, none of them have been given this 6th pay commission.
You have to give them all.
From
You have
the
to give
arrears,
all
the
of
arrears.
I beg to correct, only in state of Karnataka it is not given. In the entire country it is been given.
This exactly was the ground raised by most of the other states.
My
They
lord,
said
in
that
Bombay,
we have to give only with effect from the dates when it is possible for us financially to give.
Correct.
That was the content.
Please.
Found against Tamil Nadu in Kalyani Madhivanna.
No, my lord.
Several batch of writ petitions in other judgments in respect of each state. The Supreme Court found that it is not open.
Because each state has implemented it differently, my lord. The 6th pay has.
Your lordship,
the same day as 2006.
Your lordship, in 5th revised pay scale.
Wherever
instance,
it has been called in question. The apex court said.
Your lordship, in 5th revised pay scale, Government of Karnataka has adopted same for architecture and engineering. I am producing the notification. In 5th revised pay scale,
The other important.
your lordship may
aspect-
kindly look at the 5th revised pay scale. It is uniformly implemented to engineering college and pharmacy. Only in the 6th, they have bifurcated this. In 5th revised pay scale, it was uniform. I have produced the state government order for the 5th revised pay scale, which is uniform.
His answer is on the.
This,
My lord, the learned single judge has gone on a different premise, firstly.
So please answer us on this question of law. Your contention is that
Yes.
it can be given on separate dates for
Different.
different institutions.
Yes.
It appears that that is not the position. You cannot. The
Yes.
AICT regulations being statutory in nature, that is the finding. Under entry 66.
Yes.
There cannot be a leeway for the state governments to say that we will deviate even in respect of the date of application. That appears to be the position. Please.
I will have to do my research on that, my lord.
Yes.
But however, having said that, Now, the learned single judge has gone on a different premise totally. The government order is of the year 2011. Now, these respondents did not, they were sitting on the fence till 2018 and then choose to challenge it. And that hasn't been set aside. So when the government order has not been set aside, then the learned single judge's order doesn't hold any foot.
It does not have to be set aside going by the settled position of law. Please.
I will do
Look
my
into it.
research on, yes.
Yes. It cannot be decided.
Your
on the
Lordship,
basis-
for a moment,
If
Your
I-
Lordship, only for a moment,
Yes.
Your Lordship, what my learned friend is canvassing is contrary, because during fifth revise,
Therefore, that will have to be decided and the judgment will have to be passed on that
Yeah.
aspect.
yeah, you,
She'll have to be given time to argue on the merits of
yes,
the matter.
Your Lordship, only I am requesting to look at the fifth revised pay scale. It was uniform. I have submitted that document to them.
Yes.
Your Lordship, they are 78, 80 years, yes, a short day, because Your Lordship wanted to have it on 3rd. Now at the request, it is given 23rd. Now any short date,
These are two writ appeals, and as I mentioned, it has a checkered history because whatever the learned single judges have relied on has been with regard to UGC and the implementation of the UGC pay scale to the teachers. So my lord, I took time to look into the papers, that is, yes.
Because it is in.
But I need
Yeah.
time to do my research and effectively put forth.
After holidays, we will. Yes.
Please, my lord.
We have to hear them and pass an order.
Your Lordship, I am not for a moment against it. Because the court has already taken my protection. The court said that their government has deposited 20 lakhs because their only request is they may not enjoy the fruit because they are in 80s. The entire country have the benefit except,
There's a delay in 1185 of 20.
Your Lordship, I oppose because that appeal is not even issued notice and the court has only tagged the matter here and imposed cost. Now, if Your Lordship has to allow that, then the cost imposed, they will be having an advantage. Even notice is not been, I have not taken notice to them.
Honorable.
No, Your Lordship, the court was not inclined to, because the court wanted to issue, dismiss the appeal at the threshold and impose cost. Now, if I take notice, the government will get, so I am, let that matter be at the same state.
Yet to be heard.
Your Lordship, let the stage be in the same state.
Submission with regard to that is that I.
Because
made your
admission
lordship
of
appeal is purely discretion of this court.
17,020.
Or issuing notice, I am,
Please, counsel, don't talk at once, please.
31/7/2023, the division bench took note of this and actually said, stay operating, both these matters need to be heard on merits, which I showed you.
58, we'll hear you on merits. And
But
if there is-
258, my lord, there are no proper papers and we have filed a comprehensive writ appeal with papers in 1185. Therefore, my humble submission is, this is for the state, my lord, and I understand it needs to be heard on merits.
Yes.
So
will be
if
heard on-
notice is served, then both can be heard on merits, is my humble submission. And the delay may be condoned.
List on the next date. Please be ready on the
Yes.
question of law.
2310.
Yes.
Please, my lord.
Only 2:30. Yeah. Two matters are over. Yes, what happened to your passed over? It is not passed over. We now have only 2:30 matters left. In 2:30, we have quite a few. 2:30, we have a hearing matter also.
ನನಗೆ ಆಮೇಲೆ ಏನಕ್ಕೆ ಬೇಡ ಅಂತೀರಾ ನೀವು ನಾಮಕರಣ ಆದ್ಮೇಲೆ ಏನಕ್ಕೆ ಬೇಡ ಅವನು ಬೇಗ ಯಾವಾಗ್ಲೂ ಇದ್ರೂ ಅವ್ನು ಬೇಕೇ ಬೇಕು ಅದೇ ನೀನ್ ಹಂಗಲ್ಲ ಹೇಳ್ಕೊಡ್ತೀಯ ನೀನು ಹಂಗಲ್ಲ ಹೇಳ್ಕೊಡ್ಬೇಡ ನೀನು
My lord, this is a case where there is,
What is this?
This is
item
number 35.
on Saturday, the suit was listed for the cross-examination of PW1, who has already been caught, further cross-examination of PW1. Just a minute. I just want to make one submission before my run. He was cross-examined substantially over about a month ago, 96-year-old witness. They take time on Saturday saying they want to settle the matter. And today they're pressing the appeal here. This is the height of unfairness that I can imagine. 1 minute, I have not completed. Not only that, for the last perhaps 8 years, I have not been paid a rupee. He is a tenant in my premises. Now he says arbitration, he says this, he says that.
I'm a tenant in the property. Because my application under section 8 came to be rejected, even before cross-examining the legal witness.
When was it rejected?
No, it was,
Section 8.
5/6/2024.
No, after it came to be rejected, my lord.
And the examination, the evidence is ongoing?
No,
Yes.
evidence has started. Before the PW1 was examined, I made a submission.
List for admission and some.
No, one
Yes.
submission.
Before holidays, it will be listed for admission.
Please.
We'll see the papers also.
Lordship,
That year. That year.
grateful.
But there's a delay, my lord.
That we'll consider on that.
Please.
Madam.
Court officer?
Madam, 21.
ಪಾಸ್ ಅವರ್ ಆಗಿಲ್ಲ. ನೋಟಿಸ್ ಹೇಳಿ ಕಳಿಸಿದ್ರು.
Court officer, final hearing ಮಧ್ಯಾಹ್ನ ಆಗ್ಬೋದಾ?
ನೋಡ್ಬೇಕು ಸರ್, 2:30.
Okay, thank you.
Ma'am, ಇದು serial number 36 ಒಂದೇ matter na ma'am. The 3 matters is there for 2:30.
Well,
ಅದೊಂಚೂರು ಬಟ್ಟೆ ಕೊಡ್ರಿಪ್ಪ. ಕೊಟ್ಟಿಲ್ವ ನಿಮ್ಗೆ? ಹೊಸ ಇಸ್ಕೊಂಬರ್ರಿ ಕೊಡ್ರಿ, ಅವ್ರು ನೆನ್ಸ್ಕೊಂಡ್ ಹತ್ರ ಹೋಗಿ.
ಸರಿ.
ಬೇಕು ಹೇಳ್ರಿ, ಇಸ್ಕೊಂಬರ್ತೀನಿ.
ನಾನು ಕೊಡ್ತೀನಿ ತಗೊಳ್ಳಿ.
ಐತಾ ಬಟ್ಟೆ ಕೊಟ್ಟವ್ರ ಇಲ್ವೋ ಅವರು?
ಸರಿ ಕೊಡ್ತಾ ಇರ್ತಾರೆ ನಿಮ್ಗೆ. ನಿಮ್ ಹುಡ್ಕೆ ಬಂದ್ರೆ ಹಿಂದಿನ ಮಾಡ್ತೀರಾ ಕೈಯ?
ಅಲ್ಲ ಅನ್ಕೊಂಡಿದ್ರು.
ನಿಮಗೆ ಕ್ಯಾಶ್ ಮಾಡ್ತೀರಾ?
ಈ ಬಟ್ಟೆನೂ ಚಂದ ಸರ್, ಬೇರೆ ಬಟ್ಟೆ ಐತೆ ಚೆನ್ನಾಗಿಲ್ಲ.
My lords, with your permission, serial number 21, your lordship has issued notice. I may be permitted to take notice on the trial court advocate also, my lords.
In addition.
In emergent notice may be issued. Obliged.
2:30, pronouncement of judgment.
I appear for fourth respondent. in this case.
Appellant.
37. Thirty-eight, Jay Kumar.
2013 appeal. Has anything survived? This is, I'm sorry, sir. Sorry, sir.
Appeal is dismissed.
So sorry.
Orders 230, syllabus 39, Narsimurthy and
Amendment application is, has to be allowed. IA 1/2024, amendment application seeking
Amendment
additional facts
application
and
copies
grounds.
have been served.
We have served the copies on the other side.
All copies are served.
See, my lords, but
We
we have
have-
to file a formal objections, my lords, because it's completely new grounds to what was urged in the petition. We want to file a formal objections.
Yes.
Lord, let this matter be taken up on day after tomorrow.
When was
This-
the amendment application?
Long back, my lord. I'm not gonna.
12/6/2024.
Yes. Even if it's amendment is on the grounds,
My lords, I have some objections, my lord, therefore I want to file a formal objection.
you had some proper objections you'd have filed before.
I understand.
What are the other office objections?
Lord, non-filing of, that has been filed, I'm instructed that it is served. And synopsis also we have filed.
Amended cost title, that can only be after the amendment is allowed. Amendment is.
Yes,
not allowed.
amendment has to be followed, allowed.
In writ appeal 95, amendment has already been allowed.
Yes, Lord. Connected matters,
There, the amended cost title is not used.
connected appeal.
When was the amendment application allowed, counsel? 29/3/23. Yes, please see that it is done within a week.
Let
Yes.
this matter be listed day after tomorrow, my lord. By that time, let them also file the objections and this
Let's
complaints be made.
immediately application. Please place your objections on record within a week at the earliest, at
Wait
the
for it.
latest. Yes.
Please.
L. Venkatramana Reddy.
Filed two applications for setting aside the abatement order as well as the condemnation of delay in filing the setting aside abatement order.
Non-amendment of cost title in respect of LRs of deceased sole respondent.
And they have to file the amended writ appeal also.
Syllabus 40. Weeks time.
Yes.
Yes, do it do whatever is to be done, either side, within a week.
He has to done.
Yes. Week's time is granted as a last chance if he doesn't come on the next posting.
And Lords may kindly direct the appellant side to file the amended writ appeal as directed.
Side counsel. Yes.
41,
Stay.
Rajendra S.
I will inform order may be passed, my lords. I will inform the other appellant side advocate.
My lords, for the appellants, we have already filed a synopsis, my lords, on May, July 2024.
Records are directed to the produced in number 41, records are received. 40.
41. Is this 41?
41.
41.
41.
41.
I appear for respondent number 7 in this matter.
Yes, we'll list this immediately after.
My lords, may
All-
be taken up.
All
day
the
after
office objections are complied with.
Please, my lords.
It's submitted that the office objections have been complied with.
My lords, one humble submission, my lords, maybe listed day after tomorrow, my lords, there is little urgency in this matter, my lords, kindly. my
Lords,
lords.
after
Is the
vacation only.
agency.
My lord, the order challenge is 1979 order, my lords. The property has been, they have entered into joint development, my lords. Because of this appeal, my lords, they are not able to put up the constructions over there. Little
Lords,
difficulty,
immediately
my lords,
after
kindly, my lords.
vacation, any date.
List it immediately after occasion.
My lords, kindly, my lords,
A
next week,
date
my
will
lords.
be fixed, my
Kindly, my lords, there is urgency, my lords.
There was no urgency till, this is a 2018 appeal.
Please, my lords,
Absolutely no urgency till yesterday.
My lords-
Nobody made any submission.
my lords, it was the
Yes,
act,
please list it immediately after.
it was heard on
What's the
merits,
date
my
to be
lords.
42, HM
Yes.
Basuraja. This translation.
English translation, usual orders.
May make one submission, your lordship, kindly, my lord. This is a case where all these, the three respond, I pay for the three respondent, all the respondents. Here, my lord, that we have succeeded and we have retired from service, my lord, only thing is terminable almost on 2020. May I only request your lordship immediately after the vacation, a date may be fixed and
See that the office objection with regard, if it's only translation, only the relevant material you need translate. You need not give translations of everything. But the relevant, what you're relying on, please see that it's the
We are not going to rely upon my, we are not going to rely upon that.
on
Kind, it may be
any of
more,
the documents.
the translation copy, we are not going to rely upon.
You don't want to rely on any of the documents.
Only one,
Whatever is relevant, please make it available, counsel. That is the usual order in the
please, my
translation
lord,
matter. List immediately after vacation. Please be ready on that day.
74 days.
please, my lord.
Delay can be condoned.
please, my lord,
Delay of 74 days can be condoned.
delay that can be done.
Delay
I will-
can be
I
condoned.
have no.
Heard both sides, the IA number 1 of 2020. In view of the submissions made, the delay of 74 days in filing the appeal shall stand condoned. List for hearing immediately, list for admission. List for admission immediately after, please be ready on that day.
Please, my lords.
All the,
All the three cases.
case 45 days, in all 3 cases, the delay can
Please,
be
please.
condoned. We list it for admission. On that day, please.
Please,
Yes, yes. Please order the IAS for
Date may be, your lordship, kindly.
immediately after.
28th. 28.
Two.
28 of
Next month, next,
On that day, please be ready to argue the matter.
please, my lord.
Yes.
Great,
please.
43, Nitin Prasad.
My lord, I'm for the respondent in this case, my lord. It's a completed, this survey, my lord. Complete reported is there, only the DDLR has to be finalized with the map and you are submitting. Within a weeks, we are submitting.
My lord, concern was,
This is,
my lord, land is acquired. My lord, learned single judge has quashed the acquisition. Now, my lord, the beneficiary is in an appeal. No difficulty, my lords will decide it. But my lord, third parties are, my lord, encroaching and squatting over the property. So that was the concern, my lord, and now it is more than 1.5 years since the order is passed. State will have to take some action to prevent, my lord, encroachment. They report, my lord, they can file at their own time. Let them prevent encroachment, my lord. People are getting in, my lord, building houses. My lord, there is a brick factory that is set up.
Property or your property or the
Yes, my lord.
the beneficiary's property.
we are agreed, my lord. We are prepared and directions of this honorable court is complied and it is ready only. With the sketch copy, we would like to be submit, my lord. So it's.
Is to inspect the land and submit a report to this court as to whether any third parties are squatting or attempting to encroach upon the property in question.
We are not been disputing anything, my lord. We are only implementing of the lordship judgment only. We are, everything is ready. Encroachment report we are submitting. Encroachment reporting we are submitting. Survey is conducted, my lord. So everything is over now.
Only the next week, we will submit with a report where the encroachment is done or not as per the report. We'll submit.
12/10/23 was the directive.
I agreed, my lord. The situation,
Here is all.
my lordship, 2 elections we have been
My lord,
conducted.
there's a
in
brick
this.
factory that has come up, my lord.
There is a,
Somebody, my lord, is walking in, my lord, setting up a big factory. My lord, he is also helpless, my lord. I am also helpless. My lord, then he must do something, my lord. Then he.
Possession has not been taken over. It is his own responsibility to protect his land. It is own responsibility. In any case, I don't want to go behind the.
Unless your appeal is allowed.
Yes.
Yes.
Unless, of
Yes.
course, your appeal is allowed.
Yes.
If your appeal is allowed, then the situation is different. Yes. Yes. Please place it on record.
please, my lord.
So let the government find whatever.
Well, in that case, you may not be able to argue the appeal on its merits. If you're saying that he is still in possession. Yes, list on the 14th. Please file it by then.
14th of October.
Then no.
501.
Please, my lord.
Order to be extended.
I'm sorry, my
Order to
lord,
be
because of the delay.
Remand.
Yes. Interim
My
order
lordship
in-
is aware that farmers, how they even survey before issuing. We went to the area, how they will create it with, in spite of that, we have done.
Only to say whether there are encroachments or not.
Please, my lord.
That is the only report that is sought for.
Please, my lord.
For that, such an elaborate survey may not be required.
We-
You
we-
only have to identify the place and say whether there is any encroachment there.
Grateful.
Yes.
Grateful, man.
Yes, in 501, there's an interim order, let that be and remain in force till the next date of this.
Them serve copies on both the sides, my lord, when they
Yes.
file the report.
Please, when you're filing the report, make it available.
Great.
Yes.
44, Vedamurthy, PF R2 to 10.
We extend.
45, Mukesh V. Charity, R2, notice to order.
39 days.
Taking steps, ma'am.
Notice, yes. We extend.
46, same.
We extend.
47, Kamtar Shivrai.
Yes. 10 days time granted as sought for. Please see that it is done by then.
48.
Pen for appellate, madam. Kindly grant next week, madam.
Notice
48.
40. Yes, we extend. In the others, there is no office objection. This is no office objection. Please see that the objections are clear. We extend.
49. Geography, 14%.
What is the issue? What is the issue?
Issue regarding imposition exemplar cost by this owner for 5 lakhs. Apart from I am challenging the case on merit also. But this owner court directed the office to register the list the matter after 4 weeks. Correctly listing the matter today.
Just a moment. Non-filing of memo of acknowledgement. What is the office objection?
No office of the.
Cost has not been paid, that's all.
That is all. Yes, list it after.
This is not listing other matters, even after this owner court has given date, the registry is not listing this matter. But this matter is correctly listed by the owner register of this owner record.
Yes, is the matter, have you filed it before the,
Yes, SLP is pending.
what is the file number of the SLP?
19043/2022.
What is that?
19043/2022.
Please verify whether the SLP is pending. Yes. the registry to verify whether SLP is pending as claimed by the party in person and to list the matter accordingly. Yes. 50.
My lords, I appear for the appellant, my lords.
Please find out if
My lord, the respondent had to file its objection.
Non-filing of objections to IA 1 of 2022 for stay. What is this about? 2022 appeal.
Please, my lord. My lords, we had challenged the show cause. There were several
This
irregularities.
was immediately after, if the
Please, madam.
objection is being filed in the
Please.
meanwhile.
There's
let it
interim
be.
order in 50 and 50.1.
Yes.
Both may be extended.
Yes. it's
And the
after
counsel for-
vacation. In the meanwhile, in case the respondent intends to file any objection to the IA for stay, the same shall be on record by them.
In 50.1, my lords, my name may be reflected.
Please.
Tushal. Any date, my lords?
28. 51. You Prasad.
The appellate, my lords. My lords, the direction to the response to file an affidavit.
I raise for some more time to file affidavit, my lord, because the matter is,
Yes.
my lord, your lordship may have it immediately after vacation, we'll file our affidavit. my lord.
Final chance.
Learned counsel for the appellant seeks time to place,
Let's appellants in the connected matter.
yes, in
In
606.
606.
Please, my lord.
The learned counsel appearing for the appellant in appeal 606 seeks time to place the affidavit on record just immediately after holidays.
Please, oblige.
Sam at 1998.
Please.
52, my lord. We have already filed a report, but it has about 233 pages, my lord, wherein the copies of annexures which were produced by the petitioner and by the other respondents in the writ petitions are annexed. They're all Xerox copies of Xerox copies. So it is taking a little time, my lord, 232 pages typing and translation. My lord, it is already being done, my lord. I'm praying for time till 21st October, that would become 4 weeks. By then we will comply with the office objection, my lord.
Your lordship,
The office objection is with regard to translations.
Translation, clear, typed and translated copies of all annexures to be filed and copies to be served.
All annexures may not be required, whatever is relevant.
My lord, some of them are already a part of the writ petition. They had already submitted on the last date.
Those are not
Yes, my
required.
lord. I have sat and verified with the officer.
Only what is required you need to do.
My lord, some annexures which we produced in the comprehensive report are already typed and translated copies available in the writ petitions.
Need not. you
That
just
I
have
am
to
not
refer
file, that I am not typing.
Even the others, whatever is according to either of you, whatever is relevant, please make it available.
Because
Otherwise, just simply spending time for translations is not required.
that
Because
also I shall communicate to the concerned, my lord.
See that
But,
whatever is relevant is on record.
Lord, your lordship may kindly see the R sheet,
Hmm.
29/11/2022.
Hmm.
From then till now, they have taken sufficient time.
Only-
My lord,
only this.
one second, bear with me for 1 minute, my lord. I'll not take more than 1 minute. Now, my lord, this is 5th round of litigation by the government.
Hmm.
All 5 rounds, the government have suffered an order, and now, my lord, this is the 5th round also, my lord, the Honorable Leonard Single Judge have observed. This is nothing but harassment to the petitioner. anta heli, the 5th
What is the-
paragraph of the order of
What
lordship.
is the subject matter?
My lord, regularization of the land in question, my lord.
Hmm.
My lord, first time regularization was done.
Hmm.
They have not issued Sagavali cheat. I approached this honorable court.
Hmm.
Mandamus was issued.
Hmm.
They didn't give Sagavali cheat.
Hmm.
Contempt filed. In contempt, Sagavali cheat issued.
Hmm.
Now, my lord, again, for revenue entries in my name, I filed a writ of mandamus for revenue entry. They didn't enter my name. I filed contempt.
What is the contention they are taking?
My lord, now what had happened is, my lord, in the meantime, my lord, without making the party, my lord, it was challenged before the Karnataka Appellate Tribunal also. There also we have won, the petitioner got a respondent got a favorable order. Now, my lord, again, without making the petitioner as a party before an assistant commissioner, a proceeding commenced for cancellation of this thing. He passed an order, cancellation of the grant regularization made in my favor. That was called in question before the Learned Single Judge. Learned Single Judge has taken note of all the previous round of litigation, including the order of the Karnataka Appellate Tribunal,
And
which has
directed-
that has attained finality.
And directed,
And directions.
and directed what?
Lord-
What did the learned single judge direct?
My lord, he has dismissed the order of the, he has set aside the order of the assistant commissioner.
Hmm.
because revenue entries were standing in by name. So therefore, my lord, the learned single judge have observed, it is nothing but a harassment to the petitioner by at the hands of the government. And, he has been harassed, and the learned single judge observes that also in paragraph 5 of the judgment.
Yes.
Now, my lord, from past 1.5 years, because the pendency of this writ petition, this appeal, my lord, I am unable to enjoy because time and again the officers of the government will come and disturb my possession.
Time granted, please take down the order. Time granted for production of the translated copies of relevant documents. The
607.
relevant documents shall be translated and made available before this court on the next date of hearing. List
Sorry,
immediately
my
after.
lord, there's some confusion. I was submitting for 53, my lord. My lord, 50, that is why I'm wondering, state is not an appellant. I got confused. My lord, in serial number 52, my lord, office objection is that regional commissioner is no longer a party. That had to be complied with, my lord. That office objection may kindly be overruled, my lord.
Yes.
My lord, any date it may be called immediately after.
Tomorrow itself, my lord, I'll argue. I'm ready.
The objection
I
is
should-
overruled, list immediately after holidays. Even
My lord, may I
After
request one
vacation,
more?
my lord.
My lord, they will come and disturb possession, my lord. That is the
14th. Yes.
My lord, 53, my lord, I'm praying
Please, the
time.
case. Please make available only the
lords.
relevant.
Small submission in this matter.
Yes.
This honorable court had directed the state to file a report in June of 2023 within a period of 6 months. 16th of January was the date fixed.
Report is available.
Report is available. All the annexes that are filed, I myself and my learned counsel on the other side, we have filed translated copies, barring only one document. This submission I made on the last occasion also, conditional order was passed. They're yet to file translated copies.
Yes. Don't let us list it, let us overrule the office objection.
Kindly,
and
my
list
lord.
it.
Kindly, I can
So
show from the records, any date may be fixed.
Your documents, you were,
Yes, I have filed all the relevant documents, I have filed translated copies.
what is the requirement? Let's have it, let's overrule the office objections and see whether anything.
Or they can verify.
They can verify.
They can verify and make a submission on the next date of hearing. Date may be fixed is my.
Courts have directed, my lord, whatever relevant documents we are also going to rely upon, only those actually instruct the office.
Yes.
As of now, they are getting 234 documents.
Absolutely not
translate.
required.
I shall also verify.
Most of the records.
Some of the
The
documents.
original in vernacular is here.
My lord,
One of us knows the vernacular.
my lord, some of
What is the
them typed
difficulty?
copies and translated are available. That I have already segregated.
Important
Yes.
documents are in English.
Yes, yes.
That is already segregated by me, my lord. Only
Yes.
other documents are being typed.
Office objections are overruled for the time being, list immediately after holidays. On
Great,
that
sir.
day, please, if there is anything further that you wish to rely on, which copies have not been made available by the other side, only that.
Yes, ma'am.
Sir.
Yes,
21st October. ma'am.
21st October.
Great.
54, Vasant Fernandez.
Yes. Copy served?
Copies are served, my lord, also sent to the party. Court notice to the party has also been served. The thing is on 16/12, an order was passed by this court. On the same day, we took out process and a memo was filed by the counsel for first respondent seeking that he be permitted not to appear in the case. The thing is, he has not been appearing despite that, but the court therefore issued notice on the last date. That notice has been served according to the postal information. On 12/8/24, it has been served.
Notice issued to the respondent, Sri Amla Das, and it's served but under.
Served and unreleased.
Served on 12/8/24.
Yes, it is submitted that the notice to the first respondent has been duly served, but the respondent is unrepresented. But the said respondent is unrepresented before this court. List, now what is the stage?
It's admitted and stayed, my lord, so it would be
List on. Yes, the office objections therefore stand complied with. List immediately after holidays.
my.
55. Then the
This
Kishore.
is a, last time it was under.
Appearing for the appellant, your lordship.
Final disposal.
Your lordship,
Short question is, under section 11A, if the proceedings are lapsed as on 1/1/2014, that now the interpretation by the apex court is, it won't revive, it will not continue under 24(1)(a). This is what exactly the facts of this case. 2010, the petition has been allowed with a direction to pass an award, and no award has been passed. And both of us filed a writ, both landlords and the APMC, they filed a writ appeal. Writ appeal was dismissed. SLP was dismissed. In the SLP, liberty was granted so far as my arguments are concerned. The provisions under section, under 2013 Act, if no award is passed, no compensation is paid, that liberty was granted. Therefore, we filed a writ petition. The first is section 11 capital A millets. The award has not been passed. We filed a writ in 2017. 2020, when the matters were heard finally, they have come up with an award, that to a government order dated 7/1/2020, approving the award passed by the land acquisition officer. Land acquisition officer claims he passed an award in 2018 when the writ is pending. And government modifies it. In fact, your lordships are aware of it, that the Supreme Court said, so far as the land acquisition officer award is concerned, since he is an agent of the government has no power to modify the award passed by the land acquisition officer. And whatever the award passed by the land acquisition officer, the government modifies it and places an award order before this court. The learned single judge said, since 11A proceeding, when the writ of mandamus was issued, after the disposal of the writ appeal, there was no interim order pending before the SLP. Therefore, 11A was pressed into service. That's the position. Assuming but that millets, that 11A may not be applicable as per them. But in view of the judgment of the apex court reported in 2022, 2 SCC, page 772, paragraph 31, where it says, Malad, under the new act, award should have been passed within 1 year. That is 31/12/2014. The learned single judge, Malad, gives all alternative dates. Award was not passed within 2 years. Award is not passed within 1 year. Therefore, the proceedings get lapsed. That's the position.
For the appellant, Your Lordship. Your Lordship, my senior's mother has passed away today morning at 10:30. So if Your Lordship could grant a short time, we'll appear, Your Lordship.
Yes.
Sorry, I'm
You are appearing for the respondent.
Learned counsel for the appellant submits that there has been a bereavement in the family of the senior who was engaged to argue this matter. List immediately after holidays. Yes.
I'm sorry, I was not aware of it. Otherwise,
Much obliged, Your
time
Lordship.
it was understood for. This is a short question.
We'll
Please.
consider it on the next day.
Please.
Yes.
Much obliged, Your Lordship.
May I appeal to your lordship, some date may be given.
Okay.
Please.
56. Hindanur Vishwanath.
Steps taken, my lord.
Waiting service of notice.
Yes, steps. R1, please.
List it immediately after.
Please, my lord.
If a date may kindly be given, Your Honor.
Yes.
21/10.
Greatly.
57. Naveed Ahmed.
Last date of vacation, I had filed memo of calculation. They have filed objections. They have served me a copy today. Get the instructions. The only thing is, we have given a deposit of 1,50,00,000 lakhs. Only on that we have to discuss.
My lord, after giving deduction to the advance amount, my lord, according to them, they are liable to pay 37,88,984. But my lord, as per the agreement, my lord, is supposed to pay the rent as well as 18% of GST amount. My lord, GST amount has not been included in his memo of calculation. Then as per the agreement, my lord, the TDS has to be deducted. He has not given the certificate of deduction. So therefore, if all those things are complied, my lord, according to me, my lord, still liable to pay 2,04,46,000.
But TDS, if it is given,
Calculate-
GST is not calculated here.
Yes.
I'll just clarify with
Yes,
that.
please do. When
After vacation? No vacation.
Next week can be done, tomorrow itself this calculation. There is much,
Friday, we'll make an attempt. Friday. 7.
This week.
9. 58. Vaishali Srilakshmi.
Withdrawing the appeal.
You withdrawing? Yes. The learned counsel or the appellant has placed a memo on record seeking to withdraw the commercial appeal.
Manoj, I don't have a copy of the memo.
I've not sought for any liberty.
I hope they're not seeking any liberties.
I've not.
No.
Yes, the above you have.
Manoj, I don't
The-
have a copy also, but I will
Bill
insist now.
is dismissed as withdrawn.
That's all.
Nothing else.
That's all that I've said.
59. Fragrance Jigai.
Translated copies.
Yes, my lord, the relevant translations copies I have produced, my lord.
Yes.
It is a
the
selection matter.
Office objection is dispensed with. Yes, if there is anything that we require, we'll ask you.
I will do it.
Yeah,
I will do
so when will
Like-
we hear this?
It is a selection to the post of my lord police sub-inspector. Where my lord, my grievance is regarding my lord
Ready?
evaluation.
For consideration of interim priority.
My lord, notification.
Hmm.
My lord, dated.
Hmm.
21/1/2021, annexure A1.
21?
21/1/2021, annexure A1.
Hmm.
Where there is a prescription of my lord, written examinations consisting of my lord, 2 papers. My lord, translated copy I have produced. My lord, at page 166 the relevant, my lord.
Hmm.
Where paper 1 is consisting of my lord, descriptive type, where which is in Kannada as well as in English. And paper 2, it is consisting of objective type questions, my lord.
Hmm.
Now, my grievance in this case is regarding,
Hmm.
my lord, the evaluation of the first paper 1, my lord, descriptive type answers,
Hmm.
where, my lord, 19, their own circular and the notification prescribes for, my lord, 2 evaluations by the 2 examiners.
Hmm.
And if difference of marks is 15 is there,
Hmm.
refer to the 3rd examiner.
Hmm.
Your lordship may kindly see, my lord, page 167, translated copy of the notification, relevant extract.
160?
167, my lord.
Hmm.
Candidate can answer essay writing in part 1 in English or in Kannada. 2,
Just a moment, where is all this? 167.
167, my lord.
Candidate-
Instructions,
yes.
instructions, I'm sorry,
Hmm.
I apologize.
That's
167, instructions, my lord.
Hmm.
Candidate can answer essay writing in paper 1 in English or Kannada.
Hmm.
2, paper 1 answer sheets will be computerized and secondary and territory evaluated. A decision of the additional director of police recruitment chairman regarding the conduct of the said proceedings will be final. My lord, kindly say, my lord, in support of this, where, my lord, 2 elevation has been done at the first level. My lord, circular is dated 5/2/2019. My lord, translated copy I have produced at page number 372.
372.
372, my lord. In the bold column in the bottom, my lord,
Hmm.
I'll read it from paragraph 3, my lord.
Hmm.
For greater accuracy of the said evaluation process
Hmm.
and to reduce the subjectivity as much as possible, and because this subjectivity should not inconvenience any candidate,
Hmm.
it has been decided to adopt the model of secondary and territory evaluation process adopted in the Karnataka Public Service Commission in the evaluation of the written examination paper 1 for the post of police sub-inspector. The Karnataka Public Service Commission manual as mentioned the following regarding the evaluation of the answer papers.
Hmm.
Each script shall be subjected to double or triple evaluation as may be necessary by 2 or /3 different examiners evaluators if the difference of marks between at first and second evaluation is less than 15 of the total marks of a paper, then average of the total both valuation marks is taken as the marks secured by the candidate in that paper. If the difference of marks between first and second evaluation is more than 15, then such answer book share subject to third evaluation. The case of the answer book subjected to the third evaluation, the average of the nearest total marks of the two evaluation marks shall be taken as the marks secured by the candidate. After third evaluation, if the difference between the marks awarded by the three examiners are found to be equal, then highest marks awarded by any of the two examiners shall be considered for the purpose of calculating average marks. Since the first stage evaluation process of the written paper, test papers, one for the post of police sub-inspector civil has already been conducted and completed, it has been decided to implement the second, third evaluation process for the reasons explained above and to follow the KPSC model.
Just a moment, just a moment. This is a circular dated 5/2/2019.
19, it is last line, your lordship may see, my lord, it is adopted all subsequent examination. I'll read my last line. The evaluation process will be carried out accordingly. Also, it has been decided to conduct the evaluation of the answer sheets of the paper 1 of the written examinations for the recruitment of the post of police sub-inspector for all groups to be conducted henceforth as per the process prescribed above. 19 only, during the course of 19 examination, my lord, first time, my lord, the selection committee adopted this method, and adopting this method only, my lord, notification was issued in the year 2021, where, my lord, I read that page 167.
Yes, let us go right to the finding of the tribunal on
No,
this.
no, my lord, what they did is, my lord, in the first round of litigations, my lord, it is a second round of, this selection is, my lord, once, my lord, it is, round, it is came to the High Court had sent to the, my lord, to the fresh agency, where, my lord, earlier selection committee conducting the, my lord, dual evaluation. However, my lord, after the litigations, my lord, when the matter is entrusted to, my lord, KEA, as per the directions of the Honorable Court, my lord, now KEA, without taking any instructions, my lord, conducted only one evaluation, which resulted in, my lord, the marks, certain candidates got the higher marks, certain evaluations, my lord, and my lord, evaluated rigidly got lesser marks.
On perusal of the contentions by respondent number 2, Karnataka Examination Authority, it is revealed that the KEA has adopted valuation process by which two examiners have evaluated the answer scripts at first level, and then the answer scripts were reviewed by independent reviewer. This formula adopted by R2 seems to be without any bias. The applicants have not made out any case of mala fide or other irregularity in the process. From the documents on record, we are of the considered view that there is no irregularity. Therefore, as a matter of fact, tertiary evaluation has been conducted 1, 2, and 3.
No, they have not done like that, my lord. Kindly see the reply statement.
Yes.
Pager, reply statement.
No, this is the finding of the
Reply statement page, my lord. Kindly see, my lord, what they stated in the reply statement. Page 353, my lord, para 6. It is submitted that since the paper 1 consists of both English and Kannada language subjects, this respondent got the paper 1 evaluated by English and Kannada evaluators separately, and both of them have awarded separate marks. Thereafter, to achieve fairness in the process of evaluation, papers were referred for verification by 2 more verifiers who verified the correctness of the award of the marks by the evaluators and have signed a score sheet of the answer skips. This is not the method adopted, my lord, earlier recruitment and the previous round, my lord. It is exactly
that was only procedure which was adopted by the
fourth respondent. Fourth respondent.
Just a moment. Please show us the judgment by which it was entrusted to KEA.
High Court judgment page number. My lord, it is 283. My lord, last writ petitions are dismissed. They ensure fair re-examination.
Just a moment.
I'm sorry. To ensure for fair re-examination, the state government shall entrust the process of re-examination to an independent.
Yes, from 45 onwards, the allegation that the recruitment being involved in the scam is the option exercised by the executive to cancel the examination to all. 283.
83, my lord, last line. They, in the last line, they have entrusted it to they are directed to entrust it to the new agency, my lord.
Therefore, we hold that the order passed by the state government in the facts and circumstances of this case is just and appropriate and does not call for any interference. Accordingly, we answer the point in the negative. For reasons recorded here and above, we are at one with the view taken by the KSAT, and therefore the impugned orders do not warrant any interference.
My submission is, my lord.
Must to ensure fair re-examination, the state government shall entrust the process of re-examination to an independent agency without charging any fresh fee from the candidates. Therefore, the independent agency, which is entrusted with the conduct of the examination, is also free to devise it unless you can show
No notification.
that the procedure adopted by the independent agency, which was entrusted, is
it is contrary to the notification. My submission is, it is contrary to the notification.
Where in the notification does it?
My lord, notifications of page 167, where, my lord, issued by the, my lord, earlier by the selection committee, my lord, in the year 2021, clearly says, paper 1 answer sheet will be computerized and secondary and tertiary evaluated. My lord, this particular part has not been done by the new agency, my lord. And the decision of the additional Director of General Police Recruitment Chairman regarding the conduct of the said process will be final. My lord, which I just read, that earlier proceedings, my lord, were adopted, where they have decided to adopt the same method as method adopted by the KPS. My submission is, they evaluated Kannada 1 examiner, English 1 examiner, but the total answers were not examined by the 2 evaluators. And my lord, 38
reviewers also.
My lord,
2 reviewers as well.
Earlier what they did is, my lord, entire answer sheets were, my lord, computerized and evaluated by the 2 experts, my lord. Without, my lord, influencing, my lord, the earlier.
They have to be secondary and tertiary evaluated. That is all the notification says.
That has not been done.
Else is some kind, and where did that leave you?
Well, one evaluation is done, my lord.
Examination was tainted.
My lord, my lord, kindly see, my lord.
Examination conducted in accordance with the notification was completely tainted by malpractice.
But notification is not changed.
Notification may not be changed. Only the notification remains. Nothing else remains.
My lord,
because whatever be the method adopted, everything was tainted in the earlier round.
But it is
by malpractice in the examination itself.
That is over, my lord. I am not. My lord,
found it fit.
My submission is, my lord, when the matter is entrusted to new agency, my lord, they have to stick on to the notification because there is no other instructions issued by them. And the 2019 circular, they are not disputing. They are not stating that, my lord, we have followed this notification. They say we have adopted our own independent method of evaluation. That is impermissible.
Yes.
That is impermissible. Kindly see, my lord, tribunal. And they have not notified at all. They have not notified about the manner in which they are going to, my lord, evaluate. And 38,000, my lord, answer scripts were evaluated within 5 days by the single examiner.
Yes. Hear the response.
Lords, insofar as the notification is concerned, Lords, all that the notification says in Kannada, my Lords, originally, it says double or triple valuation. That is what we use. Nowhere we say, my Lords, that it will be triple or it will be double. We have said we are going to do a double evaluation. In Kannada, it says Ditiya or /Tritiya, it says. It's a double evaluation or a triple evaluation. I can adopt either of the two. The proceedings that my learned friend is referring to, my lords, has not been incorporated in the recruitment rules. So therefore, my lords, my lords, as per the recruitment rules, my lords, recruitment is conducted by the recruitment cell, which is headed by the my lords ADGP. Earlier examination, my lords, the state found once the provisional select list was issued that there were malpractices, my lords, on different counts, including Bluetooth malpractices and other malpractices. So therefore, state decided. In fact, the head of the recruitment cell, that is the ADGP itself, was the main accused there. So therefore, my lords, state took a decision to cancel the examination and order for a re-examination from the stage of the examination itself. That was challenged before the KAT by the persons who were in the provisional select list. Unsuccessfully, my lords, therefore matter came up before this honorable court. Before this honorable court, my lords, this honorable court said, my lords have seen the operative portion. For the sake of transparency, it is better that because it is not an independent agency. As per the rules itself, it is the recruitment cell of the department that was conducting this. So it should be entrusted to a third party agency. Now, when we entrusted to KEA, my lords, what KEA did, there are two papers. The issue here is only with regard to paper 1. Let's paper 1 here has, my lords, is a 50 marks paper. It is, you can answer it in either in Kannada or in English. Now, essay writing, one question is there. It can be answered either in Kannada or in English. Then, my lords, there is a translation paper, the translation question, where, my lords, that it has to be answered as a translation, which is from English to Kannada, a Kannada to English. So therefore, my lords, it has to be answered in English. The third question was a precise writing, which was in Kannada. So you have to make it a short form. So therefore, the answer script would contain both an English answer as well as a Kannada answer. What KEA did was, it got evaluated each paper by two persons, two evaluators. One a Kannada expert, one an English expert. So that it could, because the answer is in both mediums. So therefore, my lords, they even went to the extent of having one Kannada examiner, one English examiner, basically a person who is competent in both. And my lords, they got it evaluated. The additional cross-checking is with regard to the marks. Each person, my lords, has cross-checked it. Now, tribunal, my lords, there are 3 applicants herein. If their grievance, my lords, is in fact that there has to be a third valuation. Third valuation, how it has to be, it has not been notified. Rules do not specify that. Some proceedings of 2019, which is just a proceedings of the ADGP, which has not been incorporated into the rules. So original answer scripts, my lords, were placed by the KEA before the court. It has been perused. Kindly see one finding, my lords, of the tribunal.
We have perused the documents, additional documents, judgments. So order process shall be entrusted to independent agency. Re-examination conduct.
Para 17 minutes, page 83.
Yes.
My lords have it, notes. The learned counsel for the respondent to contends that there is no deviation in the pattern of question paper. The script has been examined by 2 different examiners, kindly noted, and evaluated. The same has been reviewed by independent reviewer, who after review has given marks. We have gone through the Xerox copy of the booklets of the 3 applicants made available by the respondent number 2. For paper 1, the questions and answers are in form of a single booklet. It consists of both English and Kannada language subjects. It has 50 marks, out of which 20 marks for essay writing, 10 for precise writing, and 10 for each for translation from Kannada to English and English to Kannada. Notes, I stand corrected. They're both translations. On perusal of the document, it reveals that the paper 1 is evaluated by both Kannada and English examiner, who have both signed along with their code. The same has been reviewed by 2 reviewers along with their code names and code numbers. The contention of the applicants that they were not aware of the evaluation process does not seem to be correct. As in the last page of the booklet, the method of evaluation, marks by examiner and reviewer, is mentioned.
Oh, the booklet in which they answer.
Please, notes.
We have made available to the court.
And not only that, Milords, if a recruitment notification specifically provided a detailed procedure, I was bound by that, Milords, in view of Bedanga Taluka, unless I deviate from that, or this honorable court issues may guideline. Now, Milords, all it said, the one single sentence says that the valuation shall be conducted by double or triple valuation. This is what it says, or triple. It does not say triple. How it has not, nowhere it has been specified, neither in the rules. They are relying upon one proceedings.
On perusal of the contentions by respondent number 2, KEA, it is revealed that Karnataka examination method, the valuation process by which the examiners are the answer scripts at first level, then the answer scripts were reviewed by independent reviewer. This formula adopted by respondent number 2 seems to be without any bias. Applicants have not made out any case of mala fide or other irregularity from the documents on record. We are of the considerable. Yes.
My submission is the notification, this honorable court has remitted the matter to the Malad, directing to entrust the examination to the new agency. But contents of the notification has not been Malad altered by either by the Honorable High Court or by the Malad, the selecting authority.
Yes.
Malad, the earlier round of, my lord, examinations from 2019, they have conducted, my lord, examinations and with the 2 evaluations for Kannada as well as in English. Now, what they did is only 1 evaluation for Kannada and 1 evaluation for English they did it. Well, it is clearly, my lord, since the different examinations are going to, my lord, we evaluate the answer scripts, my lord, there is a heavy discrepancies in the marks awarded by the each examiner. Kindly see the Sanjay Singh's case of the FX code.
Just one clarification, my lords. Each paper was evaluated by both Kannada person and English person. I think
No,
Kannada-
no, my lord, let them file that affidavit. They have not done that.
What does, see the
Kindly
papers,
say, my
my
lord, if they conduct,
Finding by the tribunal.
if they, my lord, conduct the, my lord, 2 evaluations for
Have
Kannada
you-
and English, my lord, I
Have
have
you
no case.
raised, any malafide as against the tribunal?
My lord,
Yes, we'll consider. We-
kindly
we're
see,
not
my lord,
inclined
para
to grant-
23.
We are not inclined to grant any interim order as of now. We'll hear you on the merits of the matter
Please.
immediately.
Let him not, my lord, publish at least the final select.
No,
my lord.
No,
This is sorted once, my
Pass
lord.
any interim.
Once it was already
Because, my lord,
sorted by them.
Yes.
grateful.
Notice. Notice, my lord,
Yes.
a short date may be good.
Takes notice. Yes.
Short date may be good.
Yes. Then list it only after. Then don't let it be listed every now and then. Yes. Final hearing. Number 60, R. Chandrana.
Records are secured, money, but they are totally in pieces, money. The entire Darkhast register. So, my lord, I am told that in 2014, there was some scanned copies done in the office at that point of time. I will also verify from them, from the office, they will verify and get back to. This register is totally of no purpose, my lord.
We'll await the copies of the records. Records are
The
required.
certified copies were issued to them. If on that only they want to argue, they can go on with the matter.
Copies are produced and there are records. Earlier, the court has looked into these records and
Look at the state of the records. This is what.
All this exercise was once done.
Yes, ma'am.
And what is contained in that, this thing is also noted in the order.
Therefore, it may not be required. The verification of the
By
record.
itself may not be
May not be.
this thing. Of course, if there are scanned copies, let them get it. If they are not,
Then we'll have this immediately after holidays. Anyway, today, hearing the matter may not be.
Because once in 2014, my lord, the deputy commissioner was present and they produced the records then. At that point of time. Thereafter, they say that they may be scanned. This is totally of no use, my lord. There are all the documents, not only this particular Darkhast register, the entire register, my lord. I'm not aware, 1937, 38 documents. my lord. So if they have scanned copies, I shall produce them on the next date, my lord, or I'll submit.
Yes. The learned government advocate submits that 21st records were called for. The state of the records is not conducive for an examination. As the records have disintegrated to a very bad extent. It is submitted that if scanned copies of the records are available, the same will be perused and necessary documents will be produced. Please, list after holidays.
today at page 205, when the records were earlier produced, the learned single judge has noted this is what is contained in the record.
That is so we can hear it even if the records are not, even if the scanned copies are not available, with what is on record, we'll
Because, my
consider.
lord, at that point of time, they have obtained certified copies. So that is,
Copies, absolutely.
they're already producing that. This is a matter which is restored back to file. My lord, the copy of the writ appeal is not available because it's a disposed of matter. I've requested the counsel for the appellant to serve a copy, my lord, so that it will be easy for me to argue on the next date. I shall take it, please, after vacation.
Please. 21, 21, 10.
61 adjourned, 62 government advocate.
My lord, in this matter, my lord, some reports are to be. Additional Advocate General, Mr. Santosh Gogi will be appearing in this matter, my lord. There is a direction to file a report, my lord, with respect to the daily wages. That is already ready is what my instructions are. Immediately after vacation, my lord, the learned Additional Advocate General will be present, my lord.
But my only concern is, for last 22 days, we are not being given because we have filed a contempt, our salaries have been stopped. Can we live without salaries?
Yes, what do you say? They were being paid their wages till now. On account of the fact that they filed a contempt, the wages should not stop. What was the direction?
My lord, any action in terms of the directions given in para 4, Group C and Group D, classifying persons in different categories and instructions on pay scales had to be given, my lord.
So whatever that be,
There was a,
it has to be, it is not as if they've been thrown out of service. So if it is true that it is on account of their having filed a contempt that their pay is stopped, it's a serious issue. Please instruct them appropriately that their pay has to be, it cannot be stopped on this account or whatever be the.
I understand, my lord. I shall also instruct the authorities, my lord. It may be called immediately after the reopening, my lord, and Additional Advocate General will be present, my lord.
Shall we have this once before the
Please, my lord.
vacations, only for this purpose?
1st October, 30th or 1st October?
30th.
30th September.
30th September.
Please,
Let us list it on 30th. Please see that the.
I shall
pay is
take
released.
instructions on this
Yes.
only aspect and
Yes, as to
submit.
why.
Paid
for-
wages are being paid
Yes.
or not?
Yes.
My one more submission. All along we have been paid.
Correct, we understand.
Just only this month they have not been paid.
So unless there is some pressing reason, we will take that as contempt of the directions.
Only on that,
Yes, only on.
to reply only on that, whether
Only on the
wages
payment
of
of
this month have, why it's not been paid?
Yes. Learned government advocate seeks time to get instructions as to whether the petitioners before the learned single judge have been paid their wages for the current month, and if not, why? Please list on.
Not all the petitioners, not all the respondents.
Only the
Some-
contempt of court, only those who have filed the contempt.
No,
Some of them.
even, some of them has not been.
Some of the petitions.
So there should not be any incorrect submission from my side.
Some of the it is submitted by the learned senior counsel, the petitioners in CCC 1557 of 2019, that some of the petitioners have not been paid their wages for the current month without any justification. Learned government advocate to get instructions list on 30th.
Much.
30th.
63, Hari Prasadian.
My lord, I appear for respondent number 1, my lord.
I
Yes.
prefer the appellant in this case, my lord.
Yes.
Senior counsel is engaged, my lord. Kindly have it next week, my lord.
What is the matter about rectification?
It's not rectification, my lord. I have challenged the order of the learned single judge, wherein the
Yes.
learned single judge has granted civil relief in a writ petition. That I have challenged.
Can we have this immediately after the holidays?
Very well, my lord. I mean, I'm in your lordship's hands.
Yes, learned counsel for the appellant seeks a short accommodation, list immediately after holidays.
Please.
Grateful.
64, G.S. Venkat Subrao.
AICT. AICT is not appearing. Yes, what is this for? Failure.
Finally.
Just after holidays.
65, Murugesh V. Charity.
Appear for the pleading applicant, proposed respondent. There are 3 writ appeals connected. In the third matter, I appear for the appellant.
I am for the respondent.
I'm for the appellant in this case.
I am the
We are
original
engaged with
petitioner.
senior counsel. We are engaged with senior counsel.
Do you have any objection to the applications for impleadment?
I have filed objections on that.
You have filed.
Yes.
So the
Because I am the original petitioner, I have succeeded.
Now, what is the
implementing
contention?
Application may be also influences because also filed a writ appeal, saying that he had filed another writ petition where the same survey number was challenged, land acquisition was challenged. That also has come to be disposed of, but I just verified minutes, there is a writ appeal filed, but there is continuation, delay also in the writ appeal. And there is a peremptory order to comply with the office submission within 3 weeks. I don't know if it is complied or it is dismissed, I'm not aware of.
That is so, then there is no need for this impleading. We
Pleading
just have to
application
list
may
it
be
along.
considered on the next date, minutes, there is no
Yes.
urgency on the consider of implementing application.
Just after holidays.
I represent appellant in,
Kindly be fixed, my lord. The
appellant
reason-
in writ appeal number 900 of 2021, 900 of 2021, or 3.
Yes, yes.
The copy of has not been furnished to me. Actually,
It's respond-
Copy of,
the writ appeal filed by the impleading applicant.
If
that
it is
is-
not served, I will serve, my lord. That's not an
Notice has
issue.
not been ordered in that matter.
Yeah, it is, it is. I have
Listed-
served the copies to all.
It has not been served on me. I am the original owner of the land. The BDA has acquired from me and the compensation has received by me.
yes,
So the two people are challenging that ownership.
yes.
That
yes.
is in respect
Yes.
of one survey number.
This
I am fighting
after
for 8
holidays.
survey numbers.
Copy has to be served on me.
In the meanwhile, please serve copies.
Sure.
Yes. list
May I
after
request, my lord, to kindly fix a date, my lord,
date and
28.
28th of,
Earlier application was also filed by them.
A shorter date minutes because.
22nd,
Very well.
because the court officer is giving dates on Mondays. So that normally there is a chance that it will be taken up. That is the attempt, because on that day, the service matters will not be there.
Oh,
That was the intention. We'll have it on 22nd. We don't know whether it will be taken up.
One submission beside the merits of the matter, there's a 2023 matter connected that filed by the writ appeal. But as far as I verified 2020, the senior judge having roasted 2020 is the next court.
Let it go to 22. Let everything go to 22.
So I'm just submitting minutes because
Will they absolutely
tomorrow,
not
based on,
be
based on roster, nobody should challenge.
no, that will not
I
happen
don't know what the
anyway.
next roster
We are
will be.
only too happy.
I don't know what the next roster will be, I'm just submitting this anomaly.
We'll see, according to the next roster, it will come.
Wherever
Don't
it
worry.
comes, my lord, we are having pleasures to argue.
Yes,
But date may be.
22nd.
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 Great.
Interim orders, if any, will remain in force.
66, Mitchell Pradeep Kumar.
Here for the respondent.
Yes,
My lords, senior counsel is engaged for the appellants. Some short accommodation, my lords, he's on his legs. Any day convenient, my lord.
yes, so we'll have to have it immediately after
Please.
the vacations. What is this about?
My lord, I am the owner of a piece of land. The KDB acquired it. I surrendered my land on condition that half the land will be given to me as developed land. There was a scheme also according to it. They gave me the land, but they put conditions to say, like all other allotments, you must construct, you must do this, you must do that. And then they say, you've not done that, therefore we're taking back the land. So I neither have the land, nor I have the developed land, nor I have the compensation. The learned
The
judge
allowed
has
writ
allowed the
petitions
writ
are ready.
petition.
Yes, we'll have it immediately after all.
Please, my lords.
Yes, please give a date.
28. 67, Kashinath JD.
My lords, interim order may be extended.
Yes, interim order shall remain in force till next date.
67, Kashinath JD.
Here for respondent.
Yes, who appears for the appellant?
Mr. Kashin.
It's like everything is collapsing. We were under the impression we wouldn't be able to even rush through the listed. Everything is gone for a 6. It's all right, this last week before. After vacation?
68, Jaikar Shetty Hai.
Any case where both sides are ready? Yes.
69, Sharvantari Tandra.
Time for the appellant, some inconvenience with senior man. Immediate,
Yes. So therefore we can hear you. Can we not?
Not ready with the matter, my lord.
How old are you at the bar?
1 year,
More than enough. You can make an attempt.
definitely, my lords, I have, but just with the matter.
We'll assure you that we won't pass any adverse orders.
One of the easiest subjects which is being given to him actually to us. PTCL Act is very easy, settling laws.
Why don't you make an attempt?
My lords, on the next date, I'll be ready with the file on the next date.
Yes. We'll take you up on that.
Please, my lords. Interim order may be extended.
Yes.
30th.
That's right.
ಈ ಮಂತ್ ಅಲ್ಲಿ ರೀಚ್ ಆಗಲ್ಲ, ಇವತ್ತು ರೀಚ್ ಆಗಿದೆ ಅಷ್ಟೇ. After vacation.
Yes. On that date, you will be ready.
Please, my lords. Interim order may be extended.
70, Prasanna Kumar P.
69, you're ready?
Yeah, I'm ready.
Can we take it up?
I am for respondent, madam.
Ah. So then we'll have to list it after vacation.
Any next week, my lord?
Man assures me that he'll argue the matter next day. We'll have to wait for him to get ready.
Please, ma'am. Next week, my lord? A date may kindly,
Next week may not be possible.
please,
And
after
if we
vacation.
list it, it may
After
not be
vacation.
possible.
When date may kindly be granted.
Yes.
After vacation, my lord.
28th,
In ಸ್ವಲ್ಪ ಮುಂಚೆ.
21st.
Please, madam.
Yes.
November first week, my lord.
14th.
First week of November.
November 1st.
October, the calendar is full, my lord. I apologize.
4th November. Calendar is full for the senior.
You are doing the arguing next time.
It's a lot of trial court matter. Apologies, my lord. So great.
Sorry, my lord, in the lighter vein.
Please, madam.
Yes.
70, Prasanna Kumar P.
Ethical matters, I appear on behalf of the appellant, my lords. The on-record counsel, she's on her legs, my lords. In the connected matters.
What is the matter about?
My lords, this is the matter where we are challenging only with respect to the prayer B of the order passed by the learned single judge, my lords, where only with respect to the authority who has to initiate the inquiry proceedings, my lords, whether it is MD or that of the superintendent engineer of KPTC, my lords. Since it's an institution matter, my lords, the on-record counsel is not there, my lords. Pleadings are completed on the both ends, my lords.
Notice is served on all the private respondents?
Please, my lords, I appear on behalf of the appellant with respect to the appeals which I appear, my lords, has been served, my lords.
IA 3 of 22 is there, for being, is R2 on record.
These are two. Which is that?
70.4. IA.
70.4, my lord, to bring
Yes.
LRs on record, that can be allowed.
It's already there. That can be allowed.
Notice has to be issued.
Notice is not ordered with respect to.
To,
respondent. So that IA.
Issue notice. Issue notice. Which are the matters where you appear?
My lords, serial number 70.1, 70.2, 70.3, 70.4, and 70.5, my lords.
70.4, please take
Please,
up
my lords,
notice.
I'll do the needful.
71,
Grateful, my lords.
acquiesce.
Nobody expected this to reach. Hmm.
72,
My lord, in 72,
Yes.
I appear for the. I apologize, my lord. Even I did not gauge the time right, and I'm on my way to court, my lord. But I appear for the respondent, please, my lord. This is that case where the question of partnership being registered or not was raised, if my lord recollects.
Is this
Commercial.
what you call a mobile court?
No, my lord. I sincerely apologize, my lord. I thought 4 o'clock I should reach High Court, but I apologize.
What of it? Yes.
My lord, any short date, my lord, because in this, the appellant is enjoying equivalent to that of a interim order without even order of any deposit, my lord, because I had undertaken not to precipitate, because my lord was of the opinion that it's a small point and I sincerely apologize. Deeply obliged, my lord.
My apologies, my lord, I couldn't be here. But the AACT, my lord,
Item 64, ASCT, yes, please take that.
apologies, my lord, I can't be here.
Who appears against you?
The institute is, my lord, unrepresented, that's the problem.
Served and
Third
unrepresented.
and unrepresented.
What is the matter about?
My lord, the my lord, AACT, my lord, at a relevant point of time.
Hmm.
That was the authority which was required to approve, my lord, the admissions and reports.
Hmm.
Subsequently, by virtue of another ruling of the Honorable Apex Court,
Hmm.
but since it is no longer a technical course, my lord, Apex Court. holds
What
that,
is the course in question?
Pharmacy education.
Okay.
The Apex Court holds
No, it
that
is the Pharmacy Council which has to
Pharmacy
approve.
Council of India.
Hmm.
Therefore, at the 11 point of time, my lord, they did require our, my lord, approval.
Hmm.
Now that, my lord, the change of proposition of law, I have written to AACT to.
Is it your contention that they have neither your approval nor the approval of the Pharmacy Council?
At that relevant year, my lord, we had not approved. My lord, they were before this honorable. court.
Later, it was approved by the Pharmacy Council.
Yes,
That's
my
the situation.
lord. That's, my lord, they'll have to, my lord, say before the court, which they did not say. My lord, that relevant year, my lord, we did not approve. Therefore, I have written to, my lord, AACT to clarify on this aspect, whether the appeal itself should be proceeded with or not. Correct. But, if the institution were to be here, my lord, it would have been, they would have, given much material before the court. Which,
Yes, can you, have you served on the council who appeared?
No,
Before the
through
learned single
court,
judge.
my lord, it is third year. Through the court, my lord, in the writ appeal, there was.
Through the court.
Please. So the writ appeal being admitted, my lord, the notice
Just a
was
moment,
served
just a
upon.
moment. Please, let's see what is stated in the, has it been served on the council also?
May hold or.
You do have a case in
Please.
paragraph 25 of the appeal
Please,
that the Pharmacy Council also has not approved.
I had not, as of then, it was not. In fact, my lord, we did have a discussion with AACT also, but if they had, my lord, otherwise taken admission, but if it is subsequently held to be, my lord, not in accordance with law, those admissions also will get affected. Unfortunately, institution is not before the court, my lord, despite being served.
Petitions. Grievance of the petitioners that the respondents point out certain deficiency based on. so and so. In terms of circular dated 7/6/2019, extending the time for approval with certain conditions and fulfilling the said conditions prescribed, petitioners are entitled to consider appeal. Consider the representation of the petitioner in terms of the circular dated 7/6/2019 and grant letter of approval for starting the course from the academic year 1920. Compliance of this order shall be made and a decision shall be taken by the AICT in an expedient manner, not later than 2 weeks. 7/6/2019 circular says what?
Page 92, my lord, annexure.
92. Reference to Supreme Court
Honorable
order
Apex
dated
Court order.
6/6/2019 and so on. So, Parshwanath, Charitable
past.
Trust versus AICT. In view of large number of new pharmacy institute applications, non-feasibility by PC in few cases, appeal was made. In view of the above, no common decision by PCI and AICT, you are considered for LOA. Provided you submit an affidavit mentioning that the institute is willing to run the pharmacy program approved by PCI
Yes.
from current academic year 2019-20 and
Shall fulfill APH norms and procedures laid down by AICT in APH 2019-20 before start of next academic year 20.
Is it your specific case that they did not have PCI approval?
No, my lord, they did not have PCI approval, nor my lord AICT. Now, my lord, as of now, my lord, they do not require AICT approval.
Correct.
But nevertheless, they do, my lord, require PCI approval.
What does the judgment of the apex court say?
But,
Norms and
the,
regulations of specified authorities and the Pharmacy Act would have to be followed by the institutions concerned. Imparting education for degrees and diplomas in pharmacy. Yes, please inform us whether you want to pursue this matter,
Please,
because apparently those students who have undergone the also, who will be awarding the degrees now?
that may
Those-
PCI only. PCI, my lord, through the.
Therefore,
institute.
if they don't have PCI approval, the PCI probably would not issue the certificate.
Please,
permit
please.
visa.
Please.
Probably, let us assume that they did have PCI approval, because PCI is also not a party.
Not a, it was not a party in the writ, my lord. If that particular academic year, my lord, if my lord, they
Correct.
didn't have the approval, supposing they have, my lord, taken admissions and students have passed on, the court holds that, my lord, they did not approval. My lord, my lord, the interest of the students, my lord, will be in jeopardy. Which, my lord, the institution ought to have taken care, my lord, unfortunately, they are not there before the court.
Is the state a party here?
Yeah, but no, state is,
Otherwise, at least
State
the
is
state
not
could
a
have made some kind of a,
state is not a party.
gotten some instructions as to whether they are still in operation, whether those.
There may be a direction to the jurisdiction. Generally, what has been done on these cases in other matters. They go serve a copy of the notice once again on these respondents, and the respondents do not appear. Because notice is served only to them. Goes to RPA, goes to RPA. If there will be a personal service of notice, other criminal matters and other civil matters also, generally court directs the jurisdiction. Copy of this notice is handed over to the jurisdictional police. They serve upon the copy.
Just one more thing. Does the PCI have a standing counsel in the High Court?
Yes, madam. Here they have, they do have.
Can you please
Inform, my lord.
inform the
Please.
PCI standing counsel also?
Please.
And give a copy. If as a matter of fact, they did have PCI approval,
Please.
then we need not further proceed in the matter. It's
Please.
only if they did not have PCI approval also in that current year, then the issue arises.
But
Because
if-
we need not now, if as a matter of fact, they had PCI approval in the relevant year, and then they had admitted students on the basis of the PCI approval in the light of the judgment, maybe it may not be necessary to
Please.
further consider the
Please,
matter.
another predicament for me to withdraw the appeal is,
Hmm.
my lord, the learned single judge's order will be still staring at.
Correct.
So
No,
therefore,
No, you don't have to withdraw the
Please,
appeal.
correct.
If as a matter of fact, they did have, then we can say that in the light of the judgment.
it
And
is not, I'm grateful.
For your approval may
Please,
not be
please.
required, that we can say.
Rightly, so, please.
So that the students
I,
will not
that's,
be-
that's the concern.
unsuspecting students will not be
Yes,
put
that's
to
the
the-
concern, brother. Which
Yes.
institution ought to have been bothered, my lord, they did not, my lord, appear before.
In fact, the students would not even be aware of
They would
this.
not be aware. They would be absolutely
No,
unaware.
no, they are unaware.
Even in cases where there are cases, I mean, orders, students are unaware. Here is a case where they probably would be blissfully unaware. They
Please.
would have passed out also.
Yes, ma'am.
Yes,
5 years.
5 years
the-
down.
So please,
I'll have the council
let's see
informed.
whether the standing council can
Please.
help you in the matter. If as a matter of fact, they had PCI approval, let's
Please. Grateful.
learned counsel for the appellant seeks time to get instructions whether anything survives in the appeal, list after all.
Grateful.
Please.
My apologies, my lord, I could not be here when the case was called up.
So you want it on the 30th or immediately after?
Soon after vacation, my lord, take some, I'll write down.
The standing counsel may also need to make the communications.
Please,
right now.
that's the reason.
Properly, sir. My God. That is the height of responsibility. In spite of notice being served, not
Yes.
coming in a matter like this.
In education institution, my lord, that. What? Dreadful.